Adjournment request, if any, from item number 1 to 5. From item number 6 to 13.
The item number 30, 31, and 30. Only 1 day accommodation is requirement. If you are
Item number 30.
30, 31, and 38.
31 and
Only 1 day accommodation, my lord. 30, 31, and 38. 38 is hearing, and 30, 31 is for admission. Only 1 day accommodation, my lord.
1 day, then it will go
Next week, then, my lord. Next Monday.
after summer vacation. Not summer vacation.
My lord, and one more thing, my lord, 30 and 31 are two different matters. They stack together, my lord.
Let us see.
Matters are not same, my lord.
When the number comes, you will see to it. Whether it is common this or not.
Obliged.
Yes.
Item number 14 to 22.
Lordship, I beg to mention item number 11.
11.
For today only, Lordship.
Delay condonation 119 days.
Lordship.
Notices have been issued or not?
Lordship.
Notices have been issued in the interlocatory application or not? Let's see order case. Let the order case come, then we'll pass an order. We'll see to it whether it to be adjourned or not.
Lordship.
Yeah, please. My lord, I beg to mention item number 15, 1 5. I'm for the respondent, lordship.
Yeah,
Matter may be come after vacation.
adjourn.
Lordship. Hi, lordship.
You have informed the other side.
Yes, lordship. I've been informed.
May I please your lordship? Lordship, regarding item number 17, lordship, my instruction is to withdraw the matter, lordship.
Okay, fine. Wants to withdraw.
Yes, lord.
Appealing for respondent.
This is the withdrawn.
Obliged, lordship.
I'm able to respond.
You please note.
With the consent of other side, lordship, I would like to mention item number 40, lordship. Can it be taken up after vacation, lordship? We have taken consent from other side.
40.
40. Hearing matter.
Adjourn.
Wait, please, your lordship. Item number 21 may be adjourned for the day. Mr. Sheikh is out of station. And consent has been received from the respondent side.
Adjourn.
May be the lordship,
Much
lordship, with the consent of the other side, I beg to mention item 18 for a week, lordship, adjournment for a week, lordship. And for the respondents,
Have you informed the other side?
lordship, we have taken consent.
Adjourn.
Deeply obliged.
May it please your lordship, I would like to mention item number 25. It may be passed over for today, and your lordship, it may be fixed for tomorrow, your lordship.
Why? Then it will go after vacation, after summer vacation.
It may be fixed for tomorrow, lordship,
No, there is no, why tomorrow? Then why not today?
because day after tomorrow, senior will be go to Delhi.
It will go after summer vacation. Yes. If you have no urgency today, then it will go after summer vacation.
Today they are also not available.
Okay, then summer vacation, you take your own time. After summer vacation. Yes.
Any other request?
Yeah, please, your lordship. Lordship, I beg to mention item number 39, lordship.
Yeah,
Matter may be taken after vacation, lordship.
we saw the other side.
Government, lordship, I already informed, lordship.
Adjourn.
And lordship, I also mentioned item number 43 to 46, lordship.
Yeah,
They may also taken after vacation, lordship.
adjourn.
May I please? I beg to mention item number 37, lordship. My friend is apply for respondent. So lordship will come on the matter after vacation. If convenient, a date will be please.
Lordship, here urgency is our, there's a urgency, Lordship, the railway personal fund, Lordship, although my lordship directed us to Lordship, go ahead,
You
that
are objecting to adjournment?
Lordship may fix a day, Lordship, I am not.
Which date? After the, it will go after summer vacation. And
This
this
is on 20,
summer vacation, you
30
get the date.
on
date
30
from
July.
on 30,
30th July.
Get the date from the, this
Yes, yes.
office
Lordship,
after summer vacation.
Lordship,
May it please the lordship. Lordship, I beg to mention item number 41 and 42, your lord.
Yeah,
I've taken consent of other side, your lordship.
adjourn.
There's an interim order in place, lordship, that may continue.
Interim order if I need to continue to the next stage. Yes.
For orders, item 1.
May it please your lordship. But as per the last order, my lord, the payment has been made.
Who is for the other side? Yes. The file the undertaking payment is
Yes, we have given
Yes,
that.
my lord, payment has been confirmed.
fine. Equal and concept for the petitioner has submitted that pursuant to the direction given by this court on 27/5/2024. The amount the due amount has already been paid to the respondent, to the petitioner on furnishing and undertaking by him. So, in view of the fact that the due amount has already been paid on furnishing the undertaking by the petitioner, no further order is required to pass in this contempt petition. The same is therefore disposed of, notice is discharged.
Item number 2.
May I please your lordship?
Yes.
Lordship,
This is
on-
not complete.
Lordship, I have entered appearance for
You
the,
are appearing on behalf of
only one respondent, sole respondent.
only one sole respondent. Yeah.
I will be allowed some time
Mr.
to.
So and so put an appearance on behalf of the sole respondent, services therefore complete. This is go for admission,
Yes, your lordship.
this for admission after summer vacation.
There's an interim prayer that the operation of the impugn order may kindly be stayed.
That will amount
Without
to,
hearing,
lordship, that will
Your
amount
lordship,
to.
on the last occasion, the lordship, after service of notice, your lordship will
if
consider.
you are interested, then argue it out now.
Okay, then after, on the admission. Oblige your lordship.
That's all.
Item 3.
May it please your lordship. My lordship, as per the last order, my lordship was pleased to issue notice to respondent number 1.
What happened?
We have
Notice
take-
Not been served. Yes, you are appearing.
Well, I'm appearing. Lordship,
Mr. So and so put an appearance on behalf of the respondent number 1. The other respondents are represented through concepts.
but for the respondent number LR, two also I'm appearing, for all the respondents, lordship.
Mr. So and so put an appearance on behalf of all the respondents. Service is therefore complete.
Lordship.
Mr. Nath prays for an granted time to file counter to the contempt petition. Time paid for is granted. When
Lord, I prefer 4 weeks time, Lord. They have prepared an SLP. Lordship. No problem.
Item 4.
May I please, lordship, there is a delay of 4 days in preferring the appeal, lordship.
Yeah.
No, as per the office note, notice has been served on the sole respondent.
ED card indicate the area of appropriate initial visit. Yeah, as per the office report, the notices of the IA has been served upon the sole respondent. However, none is appearing on behalf of the none is put in appearance on behalf of the sole respondent. Full stop. The IA, the present IA is filed under section 5 of the limitation act with a prayer to condone the delay of
4 days, lord.
4 days in filing the connected appeal. Full stop. Connected customs reference. Full stop. Having heard the learned concept of the applicant and after going through the contents of the application, the delay of 4 days is condoned. The delay of 4 days in filing the connected custom reference is condoned. IA number so and so is allowed. This is it registered?
No, lordship. It is to be numbered, lord.
Registry is directed to register the custom connected custom reference and this way for admission.
Much.
Item 5.
May it please your lordship. My lord, arising out of a common order, my lord, 2 writ appeals were filed. One is before your lordship, one has somehow not been listed today, my lord.
Do you have any objection? If there's
Lordship,
some-
I am not in this case, in another writ appeal matter, which is arising out of same.
Who is appearing in this case?
My lord, my learned friend.
In this case, till date, notice is not issued to private respondent, my lord. Lordship, may
You are appearing for?
Lordship, I am appearing for the department. Forest department.
Forest Department.
So my assumption is that this
Forest
appeal
Department-
maybe come up with another appeal, my lord.
You are appearing for respondent.
That
In that appeal which is not listed, he is appearing there, my lord.
because since it
In this IA, you are not appearing,
lordship.
No, he is not appearing.
and you are appearing for
Forest department.
Forest Department. Forest Department is Principal Secretary to the Forest Department, Principal Chief Conservator of Forest, Divisional Forest Officer. You are appearing on behalf of all of them.
Yes, my lord.
1, 2, 3, Lord.
1, 2, 3. Yeah. Mr. So and so put in appearance on behalf of the respondent number 1, 2, 3. Let notice be issued to the respondent number 4 and 5. Returnable. 3 weeks. Yes.
Item 6.
Lord, there is a delay of 21 days.
Who is appearing for the respondent?
There are private respondents also.
Private respondents.
Yes.
Issue notice.
Notice should go.
Who is appearing for the Fishery Department? You are appearing on behalf of whom? There are 7 respondents.
Control here, sir.
One, 3, 4, 5, 1, 3, 4, 5. Lordship.
The matter comes upon for this IA is preferred on behalf of the applicant with a prayer to condone the delay. Preferred on behalf of the applicant under section 5 of the Limitation Act with a prayer to condone the delay of 21 days filing the connected appeal. To stop. Mr. So and so is appearing on behalf of the respondent number 1, 3,
4 and 5.
and 5. Let notices be issued to the other respondents. 4 weeks.
He is appearing for 2 and 6.
So and so is appearing for the 2 and 3. Let notices be issued to the remaining respondents returnable on 3rd.
Item 7.
Apply.
Lordship, there's a delay of 242 days in filing the writ appeal, Lordship. Okay, filing
Are you appearing for the respondent?
Lordship, I am for one only.
Only one. The matter comes under for consideration of the IA number so and so transfer. With a prayer under section 5 of the Limitation Act, with a prayer to condone the delay of 242 days filing the appeal. Issue notice. Ms. So and so is appearing on behalf of the respondent number. Let notices be issued to the other respondents. Returnable 6 months. Instead, ready.
Item 8.
May I please, Lordship? Along with the writ appeal, I have filed a condonation petition, IA number 17.
It's 1,000 and how many days?
74.
1,508.
1,150.
Now, earlier, Lordship, when the informed judgment was passed by the learned single bench,
Yeah.
I had filed the appeal immediately within time.
Then
But there were some defects, Lordship. So, Lordship, the file was returned by the filing section to my learned junior. Your Lordship may come to page 13, Lordship.
13.
Page 13, Lordship. Your Lordship will see that this earlier writ appeal was filed on by me on 20th of April 19.
Yeah.
And thereafter, Lordship, there were, next page, Lordship, will see that filing section pointed out some defect.
Yeah.
And the second time defect, delay condonation petition not filed, Wakalatnama is not executed properly. So, Lordship, the file was returned to my learned junior.
When?
It was returned, Lordship,
2020.
in May, and date is given, Lordship, 9/11/2020.
So after 9/11/2020, you have not
Do
removed the defects.
Lordship, pardon?
You have not removed the defects.
No, the file came to my chamber for removing the defect, Lordship, but in the meantime, my learned junior who had filed the writ appeal, she got married and went to Pune. And
Went to Pune for what? For residing or for some?
no,
loan or-
she married. Her husband was working as a bank manager.
So,
So she left for, and Lordship, it was not within my knowledge, and thereafter, Lordship, my
that-
chamber renovation work was
Sir,
going in a larger scale.
your junior, even if she has gone to Bombay, she must not have taken the file along with her. File was within your office.
Yes, yes, Lordship, file was there, thereafter, Lordship, my chamber larger scale renovation started. So I also forget, Lordship.
That cannot be.
Huh? Everything is in here. Everything is in operation in here. Huh? Everything is in operation in here. It is really a problem now. Transfer to establish the infrastructure.
उसके बाद मैंने कनेक्ट करके दे दिया था।
कोविड के बारे में देखिए, कोविड के बारे में
बीच में कोविड के इतना पीरियड में नहीं आना, 2020 के टाइम से नवंबर 2020 से दिया हुआ है ना, हम लोग ने नवंबर 2020 में क्लियर किया था। ये पूरा पीरियड एग्जाम है, लिमिटेशन है।
ये एक्सक्लूड है, ये पीरियड एक्सक्लूड हो,
फिर ये तो हाँ, ये पीरियड एक्सक्लूड होगा।
एक्सक्लूड होने के बाद 11 पे किया जाए।
Yes, what is on the merits?
Pardon,
Come on the merits. Merits of the case.
merit of the case.
Yeah, writ appeal.
Yeah, Lordship, for that I am not prepared. It may be taken
But then
on
we are
the,
ready to hear you on
on
merits. also.
Friday, Lord.
If
No, sorry, my lord,
any case is made out on merit, certainly will condone the delay.
it
Otherwise,
may be
we will
taken
find it.
on Friday, Lordship. Or even tomorrow I am ready.
Friday. Right.
Obliged.
Prepared on merit, Mr. You also.
Hello.
Item 9.
Please, I is in file praying for early listing of writ appeal
It's a
one,
matter of 2024.
my lord.
So what's the urgency in the matter?
My lord, petitioner actually is retired person and he's not well, my lord.
Huh?
Petitioner is a retired person, my lord, and he's also not well. He's suffering from certain diseases, my lord, and
When you have filed this appeal?
my lord, this year itself. This year, ma'am.
This year in which month, which?
My
day?
lord, around March.
What's the urgency? Ultimately, your writ petition was dismissed.
My lord.
No case for it. The matter, the IA comes upon for consideration of the application. Admitted only on 3/5/2024.
Hello.
That's it, come. The matter comes upon for consideration of the IA number so and so with the prayer to hear the matter at an early date. So probably they noticed that the writ appeal, the connected writ appeal preferred by the appellant is admitted on 3/5/2024 only. Stop. Hence, no case for early listing is made out. IA number so and so is dismissed.
Item 10.
Wait, please, Lordship. My lord, today is the first time, my lord, there is a delay of, my lord, 48 days for preparing this appeal, my lord. There is a private person also, my lord. Notice me, my lord.
Notice. Mrs. So is appearing on behalf of the respondent number
125.
125, let notice be issued today. Respondent number 5 only, returnable 6 weeks, registered AD.
Obliged.
Item 11.
May I please?
Yes.
I am praying for adjournment, Lordship, in mention
Adjournment. How many days delay is there?
119, Lordship.
119 days.
Lordship.
Who is appearing for the state?
I'm afraid for three lots.
You are appearing for?
3.
And you are appearing for?
1, 2, and 4, madam.
1, 2, and 4.
Madam.
What do you want to say on the delay?
Not appears to be of penury. He says penury, my lord. I'll leave it to Lordship. He says penury.
Yeah?
He says penury, my lord. He could not arrange for money to file the appeal.
Why you have filed the petition?
Lordship,
What was your prayer before the learned single judge?
Lordship, regarding Lordship compensation and appointment, Lordship.
Compassionate appointment.
Okay.
After how many years?
Lordship,
This case was rejected by DLC in 2016. He filed the repetition in 2023. It was rejected on the ground of delay. At page 90, Lordship would find of the appeal.
Yes, madam, what's in the merit?
Merit lordship,
After 8 years, you survived for 8 years, after death of your father, what remains?
lordship,
Financial crisis is already over.
lordship,
Ultimately, it's an exception, it's not a appointment, as a compassionate appointment is an exceptional. It can't be as a matter of, can't be claimed as a matter of right.
lordship, I accepted this, that we come to for after a long time.
Then,
But lordship, we managed somehow, lordship, we survived somehow.
Hmm?
We-
how somehow. You manage somehow for so long, you can manage for for your whole life.
Lordship, kindly adjourn this matter for today.
For what? Just for what?
Lordship, my senior will be argue this matter.
Where is
But
your
he-
senior?
BK Gogoi,
Where is your senior?
lordship,
Where is your senior?
he could not come, lordship, due to personal difficulty, lordship.
Matter comes upon for consideration of the IN number so and so with a prayer to condone the delay of 119 days in pending date. Present appeal. Full stop. We have also gone through the merits of the case. Stop. The learned single judge has dismissed the writ petition filed by the appellant. Taking into consideration that the appellant has approached the court with a prayer for compassionate appointment after 8 years of death of his father. Full stop. Learned single judge, by relying upon the decision of the Honorable Supreme Court rendered in the state of West Bengal versus Devdutt Tiwari, reported in 2023, SCC Online, SC 219, has observed that the delay in approaching the court is the delay on the part of the appellant in approaching the court disentitles him for any relief. And it, concept of the appellant face some time to argue the matter on merits. Stop. Time patrol is granted. List this IA number so and so after summer vacation.
Item 12.
Yes.
Yes, your lordship, that we have filed an implementing petition for the implement of Commissioner of Appeal. So the
Commissioner of
Appeal. So this may be allowed.
who is the respondent number 2. You want to implement now this Jagdish Beshya, Chief General Manager.
It's Appeal.
And we gave the direction. The matter comes upon for consideration of the application prepared on behalf of the applicant with the prayer to implead. Jagdish Beshya, the Chief General Manager, HRA, Assam Power Distribution Corporation Limited, APDCL. Assam Power Distribution Corporation Limited only. Having heard the learned concept of the petitioner and after going through the contents of the application, the same is allowed. Mr. Jagdish Bashya, Chief General Manager, is allowed to be implemented as respondent number 2 in the contempt petition. Amended cost type will be filed within a period of 2 weeks.
Deeply obliged.
Item 13.
This is I have a conversation of delay for 14 days in preparing the accompanying agreement. I have mentioned in para 5 and 6, my lord, of this my 4 and 5. Reasons of delay.
What was your prayer before the learned single judge?
The notification they relied in 2010. They failed to brought the notification, but ultimately they brought the 1977. But they brought the notification instead of 77 2010. So on the basis of that matter, my petition was not rejected.
What notification?
This is my town and country planning notification, the publication of the Tezpur master plan, under which manner my construction falls into the lowland. So it is prohibited not to be constructed, my lord.
What do you want to say?
My lord, the learned single judge had given them an opportunity to approach the Tezpur Development Authority if they had any grievances within 1 week, which they had not done, and now they have filed this with the people. So far the condonation is concerned, I have no objection.
You are appearing on behalf of
Of the caveat, my lord, Tezpur Development Authority.
Tezpur Development Authority. What about the others?
Others, my lord, they are
I am appearing for respondent number 1, 2, 4, 5 and 6. 1, 2, 4, 5 and 6. What about these private respondents?
Perhaps they have not been served.
that will go by registrar, my lord.
Notice me for them.
The applicants upon for consideration of the IU number so with a prayer to condone the delay of 14 days in filing the present topic. Mr. So and so, an appearance on behalf of the respondent number 1, 1, 2, 4, 5 and 6. Mr. So and so is appearing on behalf of the respondent number 3. Let notices be issued to the remaining respondents returnable 6 weeks registered ready.
For admission, item 14.
May I please?
Lordship, let the matter be taken after some time.
My lord, we have filed an additional affidavit, my lord. Perhaps, my lord, yesterday we have filed. It is not as a part of record, my lord.
There any scope of filing the additional affidavit in this?
My lord, with liberty from my lordships, my lord, on the last occasion.
Yeah, last occasion, but
My lord.
what new facts you have brought on record?
My lord, the new, my lord, the new
Learned
facts.
single judge has pointed out as so many irregularities.
My lord, I have,
Selection process.
my lord, I have gone through the respected learned single judge's order, my lord. There are certain discrepancies with the annexures which he has relied on, my lord. And my lord, it requires some deliberate hearing, my lord, to satisfy my lordships, my lord. And that's why, my lord, to my lord, make out a case, we have filed this additional affidavit, my lord.
Still unconscious of that. Appellant has submitted that he has filed an additional affidavit. Yesterday on,
My
the same is not on record. Registry is directed to place the same on record. Place this appeal after summer vacation.
lord. Obliged.
Item 16.
Is that compassionate upon?
मतलब compassion appeal है ना? Other appeal, similar appeal lordship has admitted.
The concept of has submitted that identical appeals have already been admitted
Writ appeal 50 of 2024 है ना?
by this court. Good stop. Admit notice returnable on so and so registered date. Connect with writ appeal number 50 of
2024.
20.
Not.
Item 19.
On the last occasion, Malak, the successful tenderer, Malak, he was directed to be made a party. We have filed the amended cost letter.
The notice has to be issued. to
Notice has to be issued.
pursuant to the direction given by this court on 13/6/2024. The concept of the appellant has filed an amended cost title Impleadment. The private respondent as party number
5, Malak.
5. 6. Stop.
5.
Party number 5. Sublet notices we issued to the respondent number, newly added respondent number 5. Returnable. 6 weeks registered. date.
Malak, may I make a prayer, Malak?
Yeah,
Can I serve a notice by email, Malak?
you get the notices, sir. Then again, they'll say,
Because the issue,
you get the notice registered AD by the.
no, the issue is that Malak, there is urgency because the work has been allotted.
Work has been allotted, that's why only we'll see to it whether.
Malak, can it be immediately after the vacations, Malak?
Yeah, immediately, returnable on so and so.
17.
So I am appearing for respondent number 1 to 4.
Mark for the.
Malak.
Item 20.
The matter was pending before the finance department. Before that, my lord, the petition has been dismissed. Your lordship will kindly see page
It was
59.
pending with the
Page 59.
59.
Yes, this is a minutes, my lord, with the chief secretary.
So why you have approached the court? When the matter was already pending?
No, pending, my lord, we filed a writ petition. Writ petition, my lord, copy was served to the, my lord, the finance department and all. Finance department did not file any affidavit. Department has filed an affidavit saying the matter is pending with the finance department. Now, court has said, my lord, Lord Singhal has returned.
That division bench judgment.
No, that is different, my lord. Now your lordship will kindly see page 60. This is a part of the minutes.
60.
60.
Yeah.
It says, my lord, to provide for lowest pay. It starts from page 58. Page 58, my lord.
58.
This is the minutes of the meeting held on
The
20.
official representative, the meeting chaired by the chief secretary and officer for what?
Yeah, this is the minutes held, my lord. And the decision is here at page 60.
Scrapping of NPS and restoration of OPS.
Page 60.
Medical treatment. Raising EL teachers, granting promotion to the junior engineers by creating.
No, no, page 60 is the relevant for us, my lord.
Relevant para which clause?
18.
18.
To provide for lowest pay of rupees so and so along with other
Provide
allowances.
lowest pay 15 along
We
with
are
the
not there.
Pension.
And
master roll
pension to the
employees,
master
fixed
roll
casual
employees, fixed pay
long
employees,
time
casual workers, work charge employees, working for long time in Assam Secretariat and various departments and the khalasis working in the field. The petitioners have worked for more than 28, 30 years. Now, second part, your lordship will receive sentence 2. Second sentence, my lord, the department will examine the matter in the light of the extant guidelines OM issued by the finance department from time to time, and the department will submit.
Where you are reading?
The page 60, second paragraph, 18,
Yeah.
18 second.
18, SKAB will furnish.
Yes,
the
second,
number
my
of
lord, the
household
next
employees
sentence, my
by
lord.
casual workers to the concerned administrative
Department,
to
the
examine
next, my lord,
the
the department will examine the matter in the light of the extant guidelines OM issued by finance department from time to time, and the department will submit a proposal to the finance department with justification. Now, department has filed an appeal, affidavit that your lordship will get it at page, my lord, 73. Relevant is at page 74.
Yeah.
Page 73.
Yeah.
Page 74, my lord. May I read paragraph 4 and 6?
Yeah.
Yes, that is deponent begs to submit that this is a departmental affidavit. Submit that upon receiving a representation submitted by the master roll workers under the Inland Water Transport Division, Silchar, along with a meeting minutes held on so and so between the Chief Secretary and the Sodo Assam Karmachari Parishad, a detailed report was sought from the deponent, wide letter dated so and so, the master roll workers engaged in so and so. Thereafter, the report was submitted on so and so. Now, next paragraph 6. The deponent further begs to state that in terms of point number 17 of the minutes of the meeting held on so and so between Chief Secretary and the Karmachari Parishad, the report was forwarded to the Finance Department, observing that presently there is no policy decision of the government OM from the Finance Department for extending the pensionary benefit. Now, what they have submitted before the Finance Department, your lordship will get it at page 76.
Yes.
Yes, 76, my lord, second paragraph will do. In this regard, the Department Assam has submitted a report on the matter and stated that petitioner Aminul Laskar and others were engaged after 93 and there is no policy decision of the government OM from the Finance Department for extending pensionary benefit to master roll workers appointed after 1493. So now the matter is pending before the Finance Department.
So then why you have not withdrawn that petition there? Why you invited this order on merits?
No, I did not invite withdrawn merits.
You have
I did not, my lord, because after the filing.
For the learned single just to deal with their issue. You argued the matter.
Paragraph 77, my lord, page 77, your lordship will consider. This is the affidavit filed in the pendency of the writ petition. Page 77, your lordship.
Considering petition.
No, page 77, your lordship. Page 77, my lord, this is a speaking order they have passed. And last.
Page 77?
Yes.
What is it?
This is the department has passed this order on the basis of the representation filed by the petitioner. Last sentence, your lordship will see. Whereas in terms of point number 18 and all, they have mentioned all this judgment and all. The meeting of the minutes dated so and so held between the Chief Secretary and the Sodo Assam Karmachari Parishad, the matter of the master roll workers working at the Inland Water Transport Division has been examined in terms of the extant guidelines and OM issued by the Finance Department and has been sent to the Finance Department on 34/24. So matter has been sent to the Finance Department.
Yeah.
So therefore, the Finance Department
When these affidavit was there, why you have insisted order on merits?
I did not insist.
This is there, sir.
Learned single judge, passed the order, on the basis of this affidavit. I did not even know that this order would be passed. That means whole of this meeting will minutes will go.
Disposed of. Contention of the petitioner.
Government has
in the subject matter of that. Yeah, that's right. We don't find any illegality. Single judges simply relied upon the division bench.
Division bench judgment, your lordship will look into, my lord.
Yes,
and there is a court.
Lordship, I have copy of the.
Supreme Court judgment. Single judge judgment. There was Supreme Court judgment. The court.
Yes.
Yes, I have seen that, my lord.
Yeah.
My lord, that was a case, my lord, where, my lord, there is a prayer for regulation of the service of the persons who have worked for more than 10 years. There, my lord, this division bench directed, my lord, that no, they are not entitled to be regularized, but you appoint them in a minimum pay scale, and they are not entitled to get pension. This is what they say.
What's wrong with that?
No, that is the order. Your lordship will kindly say that the Supreme Court judgment order
So
in one of the
Supreme Court,
case.
you just, this Upendra's judgment, you refer to the learned single judges.
That means the whole minutes of the government of Assam with the commissary period will go. Nobody challenged that. And your lordship will kindly see
It
this
is
order.
our heartening to learn that the state government is not to terminate the hustle by similarly employed last more than 10 years. Till their normal retirement, till the ground of the state government is also, I think, they are helping the excellent.
Person working as a masteral worker,
Welfare measures
belong,
better than-
Supreme Court held, they are entitled to get pension.
Without further delay, besides that, in the light of the decision of the state Punjab, that pay minimum per all workers, transfer from the reason they are not entitled for regularization, consequential benefits such as pension, etc. So now, after this judgment,
Yes.
what remains?
After this judgment, my lord, your lordship will clearly see the government has taken a decision. This is for social justice. The persons who are working for a long time
Yeah.
as a masteral worker, they will be entitled to pension. They are
Where
considering.
is that decision?
That decision, that minutes I have shown,
Minutes simply they have said for considering, there is no decision, sir.
that considering that page 69, my lord, your lordship will
Yes,
clearly see.
69. Yes, come.
This is a minutes, my lord, they are to consider. So they have not
Consider
considered the
who-
matter.
who is preventing them, even though if they, despite this judgment, if they consider.
So
then-
therefore, my lord, what has happened, my lord, your lordship will kindly say one page order from the Supreme Court.
Yes,
That order.
yeah.
It is unfortunate that the state continued to take the services of the respondent as an ad hoc for 30 years and thereafter now to contend that as the services rendered by the respondents are ad hoc, he is not entitled to pensionary benefit. The state cannot be permitted to take the benefit of its own wrong. To take the services continuously for 30 years and thereafter to contend that an employee who has rendered 30 years continuous services shall not be eligible for pension is nothing
Whether
but
their
unreasonable.
appointment was regular or
No,
not.
this
you are
is
merchant
ad hoc.
employees, temporary employees, how can you equate
This-
this? What are the
this-
facts of these cases?
This is also an ad hoc employee.
Facts of those cases, whether
Hello?
those employees were regularly appointed on the substance.
This is ad hoc, my lord, on the basis of facts, face of the record. My lord, your lordship will kindly see this decision, what my prayer is,
Nothing has
let them,
nothing has been
My lord-
decided in this case.
no, on the basis of this
Simply
minutes.
said, whether appointment of those persons were on substantive post or capacity or what.
My
in
lord,
this
that
case.
I will have to get the petition only.
Then you get the petition and then raise your.
My lord,
claim.
only one,
Otherwise, there is no illegality in this
My-
order, sir.
my lord, only one
What
aspect
was
of
your prayer in the petition?
petition is, my lord, your lordship will get to see my prayer in the petition
Page
is at
50,
page
my lord.
57.
57.
Oh, sorry, my lord.
50.
50.
Lordship.
Yes. But otherwise, most severe honorable court please to call for the record respondent as to why the detailed proposal showing detailed.
For consideration of the benefit.
For the benefit of pension as per the minutes.
That
should
is
be
so.
placed
So
with
this is what,
administrator before the final and after return.
and before that, if the learned single judge holds that you are not entitled, you get the final.
Yes, it is the judgment. What the 100 single, the 100 single judges simply followed the.
But
earlier
nobody is
judgment of the
challenging that
judgment.
minus, my lord. This minus is under consideration. It is for social justice only. Government,
You approach the state, despite this judgment, if the state government is ready to give you the pensionary benefit, take it. You are not preventing them.
no, that your lordship will clarify, my lord.
No, there is no question of clarification.
No, if the,
You have prayed for pensionary benefit, learned single judge has said, as per the division one judgment, you are not entitled for that. That's all.
no, I have prayed for, my lord, this, on the basis of the minutes, they should expedite the minutes. This is what my prayer is. My lord, I will produce this judgment, this detail of this facts, my lord.
There is no question of such. We are not going to
My lord,
consider it.
this-
We don't find any illegality in this judgment.
My lord, your lordship will kindly consider, my lord, if this case is dismissed, then the minutes goes, my lord. The consideration of the matter by the government goes.
Already, the finance department has sought comments from the administrative department and the department. As said, there is no policy of this granting pensionary benefit. That's
No,
all
the
went to NCR.
minutes is there, my lord, the minutes will go. The page,
This is to only
page,
consider.
page
Minutes will not
60,
go.
my lord.
Even though despite this judgment and despite this order, if the state government wants to give you, I mean,
This is the minutes, my lord.
these are the minute
Minute.
considerations.
For consideration, if the, in view of the present order of the court, single
Then why
judge, my lord.
when the matter was already pending before the department, why you approve?
No, this petitioner, they have come before the court only for the
They
purpose
have
of
committed a
expediting the
mistake, then
matter.
they have to pay for it.
No, because some of the petitioners are going to retire. That is the reason, my lord, we came before the court for the purpose of expediting. So, my lord, I pray, my lord, your lordship will issue notice at this time what they have done with the
There is no
minors.
question of issuing notice. We are not convinced at all.
Maybe your lordship will listen.
If the learned single judge has simply passed the order pursuant
So
to
this
the
is going
division
to
bench order.
prohibit this is going to interfere with the minutes of the meeting, my lord, with
Why
the,
you have approached, sir? Certainly,
for the purpose.
Article 226 cannot have.
No. We came before the court for the purpose of consideration, the expediting the minor.
Yeah.
Because some of the petitioners are going to retire.
Yes.
All these petitioners, they have worked for more than 28, 30 years. Some persons are going to retire. In view of the minors, my lord, we came before the court so that the matter can be expedited. That was the only reason. And nobody challenged the minors, my lord. The question of dismissing the writ petition, returning with an order that you are not entitled to get pension, that doesn't arise, my lord.
As per the minutes of the meeting should not be placed before the finance bill after return of the rule and after hearing the parties be placed to make the rule absolute, giving full and complete relief to the petitioner. What full and complete relief? You have asked for this.
No, we have
That's
asked
why
for the minutes, my lord. Page 60, my lord, full and complete relief, that's a usual prayer made in all the writ petitions.
Full and complete relief. The
No,
court
my
has
lord, this
granted you the full and complete relief that you are not entitled for that.
No. My lord, we have said, my
And
lord,
as per the decision of the division bench of this court.
as per the minutes of the meeting dated 22/9/23, we have prayed for that only, my lord. We know that as a matter of right, we do not have right for seeking regularization and seeking pension and all. But because of the minutes, my lord, with the Sodo Assam, my lord, Karmasari Parishad and the, my lord, Chief Secretary, we said, my lord, that please expedite the matter. If the government may consider, dismiss the petition, there is no bar for it.
Yes.
So therefore, my lord, I pray, my lord, that the learned single judge should not have returned with the finding that you are not entitled to get.
That finding, sir.
My lord, I
You
did not, my
invited
lord.
that.
My lord, your
Why
lordship
you
will get.
argue?
My lord, question of arguing, my lord, the learned single
Why
judge
you
after
invited
getting,
that, sir?
after getting the
You can't
departmental
find fault with
affidavit.
You can't find fault with the judgment of the learned single judge.
No,
You
but-
invited that.
No, my lord, your lordship will clearly see that his department, the speaking order said the matter is pending with the finance department. So therefore, my lord, that matter should not have been disposed of and returned with a finding that the petitioners are not entitled to get pension. That will, my lord, debar the government or prohibit the government to give any relief which they may take. This is a social justice, my lord. These persons, my lord, working for 20, 30 years. But the government has taken a decision, policy decision that they may deny it later. That's a different matter, my lord.
It's a different matter.
That's a different matter. So
Okay,
therefore, I pray
This
that
writ appeal is filed by the appellant.
your lordship will kindly consider,
Filed
my
by the
lord,
appellants being agreed
if
with
the government is not allowed to take decision.
Order dated 10/5/2024, passed by the learned single judge whereby the writ petition filed by the appellants, writ petition number 1946/2024, passed by the appellant has been dismissed. Full stop. The appellants in the writ petition has prayed that the respondent departments be directed to The respondent administrative department be directed to place the matter regarding grant of pensionary benefits to the appellants, comma, who are working as work charge employee as per the minutes of the meeting dated 22nd of September 2023 took place under the what is that, those minutes of the meeting?
Page 61.
Relevant portion is page 60.
These petitioners have worked more than 28, 30 years. So we come under that minutes. We only pray that they should consider it.
Under the chairmanship of the Chief Secretary of Assam. Full stop. The learned single judge, after hearing the counsel for the parties, has concluded that the appellants who are working as work charge employees are not entitled for pensionary benefits as per the judgment of this court rendered in case of State of Assam versus Upen Das, reported in 2017 4 GLR 493. Good stop. Learned counsel for the appellant has submitted that as the matter regarding grant of pensionary benefits to the appellants was pending, is pending consideration with the finance department. The learned single judge ought not to have passed the impugned order. Full stop. Having heard the learned counsel for the parties and after going through the material as well as the impugned judgment passed by the learned single judge, we don't find any case for interference. However, if the matter regarding grant of pensionary benefits to the appellants is pending consideration with the finance department, it is expected that the finance department shall.
May I add just one fact, Doctor? Doctor, may once come to page 77. No such proposal is pending with the finance department. It's evident from this letter.
If such, what we have written,
Because it is not clearly not pending.
just a minute.
We don't find any case for interference. However, if the matter regarding grant of pensionary benefits to the applicant is pending consideration.
With the finance department, it is expected that the finance department shall take a decision on the same strictly in accordance with law. If any proposal is pending, then only you have to take a decision. If you have already taken a decision, that's all.
We have not taken any decision. They never forwarded any such proposal. It's
So,
only a decision.
so no such proposal is pending before the finance department.
Then there's a false affidavit has
So
been filed with the
if
department.
any proposal is pending, then you have to take a decision. No such proposal is pending, don't take any decision. What you are worrying about?
My lord, only expeditiously your lordship has said within 3 months, my lord. Some persons are,
Will add one more line expeditiously and should grant pensionary
no,
benefit.
not that.
Then
3 months, no, 3
ask
months.
for something which is,
Nothing.
yes,
I'm
ask
not
for
asking, your
everything. Why
lordship
you are
has given
asking?
enough, my lord.
We have made this observation, that is not enough.
Enough.
That's all.
Item 22.
My lord, by the judgment, my lord, the advocate and the petitioner has been imposed a cost of.
And rightly so.
Secretary, my lord, succession certificate was granted in the year 2016. And we have filed a petition for the purpose of only pension, not related with the succession certificate. Your lordship knows difference between.
Sir, in those petitions, in that petition, this court has passed an order to grab, give you this 4,45,000.
That is succession benefit, madam. The whole petition is for pension. Nothing has been decided on pension. No affidavit has been filed on pension. The petitioner is named in the service book. At best, my lord, the advocate could have been asked that you make the second wife a party.
Then the proceedings regarding this succession certificate
Yes.
is pending consideration.
No. Already succession certificate has been granted in the year 2016.
In favor of?
In favor of the petitioner.
Okay.
And then thereafter, the second wife, my lord, has filed an FAO. In FAO, my lord, 1/8 of the amount has been kept, my lord, with the court, and others have been disbursed.
The issue regarding succession is pending consideration before this court. How can you
No,
claim
no.
the pensionary benefit?
No, only that succession is in respect of all those their certificates and all. That certificates and the government pensions.
But ultimately, suppose this court grants you a relief that grant her the pensionary benefits, and tomorrow this
Pensionary-
succession case goes against you, then what would happen to that?
Pensionary and succession matters are totally different. Your lordship knows
Without
about
there
it.
being, without proving yourself as a successor of the deceased employee, how can you get this pension?
No, pension, in that regard, I am ready to include, incorporate the contention of the succession certificate, whatever the case pending. But imposing cost of rupees 25,000 to the petitioner and
You are already in receipt of 4 lakhs.
4 lakhs, but
So,
this petitioner, they are very
this.
poor person, madam. He got 4 lakhs rupees, they got 9 children, madam.
But 25,000.
This petitioners, this putting a cost of rupees 25,000 each to the lawyer and to the petitioner.
Yeah.
That is only because we have not mentioned about.
Who is capable of paying this rupees, this whole cost?
My lord, who will pay, my lord, once your lordship decides the matter, because the petition has
Who
been
is capable
decided.
Out of these 2 appellants, who is capable of paying this?
My lord, the advocate is there, my lord, learned friend is there.
So
Then-
advocate would pay.
And that read
When
petition,
they
your
modify,
lordship.
they ordered that this cost of 50,000 be paid by the advocate only.
Lead petitioner is also there, then the advocate. Now, your lordship will kindly consider this aspect of
This
the
appeal
matter.
is also filed by the advocate also, na?
Madam?
In this appeal, the advocate is also appellant.
No, advocate
Yes.
is not there. Yes, ma'am.
Yes,
Sorry, madam.
it is there. This appeal is also filed on
My
behalf
lord,
of
the
the.
petition was filed for the purpose of, my lord, pensionary benefit. Only pensionary. If your lordship looks into the writ petition, that your lordship will get it at page 32. Only pensionary benefit, because in service book, her name is there along with her 9 children. And her husband died in the year 2011. Writ petition is only, but nothing has been decided on the benefit of pension, that you are entitled to get pension, you are not entitled to get pension. And the affidavit also doesn't say anything about it. Page 32. And your lordship, if your lordship look
Just
into
a
the,
minute, just-
yes. Absolutely clear. Absolutely clear. Yes. हमें देखेंगे जानेंगे ना मैं केस अपनी कॉल भी नहीं कॉल भी नहीं करेगा प्लस होता है
Yes.
Your lordship has seen, my lord,
You applied for the sections certificate for what?
for the purpose of this, my lord, leave salary, gratuity, GIS, GIS savings,
Page number 64.
page 70, my lord, yes, 64, yes.
64, judgment of the
Yes,
district judge.
yes. And ultimate order
Was
is
the-
at page
hence
7.
the petitioner, the present petitioner, in the last 3 lines of first paragraph, 4th line. Hence, the present petitioner is a first person besides being a nominee in the service book of the deceased Abdul Batel to be issued the succession with regard to the pensionary benefits. So you applied for the succession certificate for the pensionary benefits. Those proceedings were disposed of. Then against that order, the matter is pending with this court by FAO. And if that also the FAO is pending and without disclosing this fact, that I have earlier filed.
I
whether
bowed
you
down,
have-
my lord.
You have disclosed this fact in your writ petition or not?
Leave petition, we have only prayed for pension, my lord.
How can it be, sir, when the pensionary benefit succession certificate dispute is still pending? How can you ask for
No,
that?
the pensionary benefit in respect of all these leave salary, not pension, my lord.
Whatever it may be, sir, until and unless the question regarding succession is not decided, how can this court issue a direction to grant you the family pension? When the question regarding whether you are first wife, second wife, surviving, only surviving wife is.
Second wife has given a no objection certificate.
So whatever it
She is married to the second wife, married again, and she has given a no objection to us.
Sir, that is to be decided in that succession proceeding.
Yes, but in regard,
You claim
Madam, what I understand,
without
madam,
disclosing this fact,
Madam,
without even disclosing this fact, and
I bow
coupled
down,
with the fact that the advocate who is appearing in those succession
bow down, my
proceedings is
lord.
also appearing here.
my lord, I bow down, my lord. I say, my lord, it was a mistake on my part. I should have incorporated it. But
Yes,
I
you should
understand,
have
my lord,
incorporated.
that I understand that, my lord, and I will incorporate in the writ petition. But in the writ petition, my lord, it has been disposed of, my lord, even without discussing this pensionary benefit, that
There is
pension
no question of discussing when the matter of succession is pending consideration.
succession,
How
your
will
lordship
relief
may,
can at all be granted, sir?
your lordship may differ, my lord, but what I understand, my lord, succession and the pension is a different matter. Pension is a monthly. Pension is a monthly payment, my lord. Pension is a monthly payment, my lord. This has not been decided. Your lordship will decide this matter, you. Page 70. And pension is a monthly, I
Sir,
bow
you
down,
just-
my lord, I
you-
understand.
you just let me know. Suppose if the court grants you a relief that granted family pension to this.
No, I'm not.
Please.
Hello, yes, yes.
Suppose this court grants a relief that grant family pension to this appellant. And tomorrow in those succession proceedings, that succession certificate, that order is reversed.
I agree, man.
And the court orders that grant this family pension to this lady who has filed the FAO. What would remain there?
That is there, my lord, that I
That is there,
understand.
then how can you ask for that and without disclosing this fact?
My lord,
And without even impleading the second wife as party respondent. or
second
first
wife, my lord, second wife,
Or first, whatever the wife.
second wife has given a no objection.
So
But
first
I agree and I apologize, man. I agree and I apologize that it should have been
particularly,
incorporated.
sir, if we can very well say the client may not have informed you about this, but the same advocate is filing without disclosing that. That is very.
Well, I bow down, my lord, and I also say, my lord, I apologize on behalf of the
You should have apologized before
colleague.
the learned single judge. The cost has
that did
already
not-
been imposed.
That did not happen, my lord. There was no opportunities, my lord. Only thing is that, my lord, there was a misunderstandings of law, my lord. Because the pension,
Then if this appellant is a poor lady,
yeah, poor lady, man, they are
That's-
extremely
that-
poor lady.
the appellant number two may pay the cost.
My lord, the
Whole
appellant
cost.
number-
The appellant number two may pay all the cost.
my lord, that will be, my lord, your lordship, I leave it to your lordship, my lord, this.
That-
This is a-
That's why only if you want that,
Ultimately, the pensionary matter has to be
because
decided.
ultimately this appeal is on behalf of the, this advocate also, na?
Yes, that is the.
Will modify this order if the advocate is ready to pay the cost. To this extent. Then
No, you'll-
instead of the
you'll-
appellant, the petitioner shall pay, but the advocate will pay the 50,000 cost.
Hello, what I pray, my lord, your lordship will reduce the cost. Your lordship will allow me to file the writ petition, I'll modify the writ petition. Incorporating all this, because pensionary benefit, let it go separately.
Before the decision, sir.
Hello?
After the decision is there, where is the question of amending the writ petition?
No, your lordship will allow me, that's what I'm saying, my lord, because I'll have to incorporate this, then thereafter pray for pension, otherwise my pension will go, my lord. Petitioner's pension, because husband died in the year 2011.
The pension, how the pension case will go?
It will go, my lord, because in succession case, pension is not there, pensionary benefit is there.
Sir, pensionary benefits is there, but ultimately, if the succession proceedings decides in your favor, then certainly you
He
can
will
ask
not
for
get
that.
any pension, my lord. The whole pensionary, whole benefit out of this succession certificate is 4 lakhs of amount, my lord.
Whatever it may be, sir, ultimately.
But
on
that
the
doesn't
basis of-
include,
So when the matter regarding succession is pending before how the department can decide that who is entitled for pension, which wife is entitled?
but if your lordship looks into the affidavit filed by the department,
Yeah.
it doesn't say anything about pension.
They have simply highlighted
So
that
highlighted
this
the
matter is already pending.
succession
And
certificate.
despite that, she has approached this court without disclosing this fact. That is. So how much cost you propose on reduction? Only for the appellant. Only for the appellant, advocate has to pay the whole amount.
Let it be 10,000 for both.
It's very less.
I'll pay to the legal service. also. I mean, I've committed a mistake, that I understand.
But every,
I accept it. now.
every mistake has to pay,
Yes, I'm saying to the,
has to pay something.
let it be 10,000 rupees. my lord. I'll pay to the.
There is an old saying, हर गलती कीमत मांगती है, वो कीमत देनी है.
हम कीमत दे रहे हैं, 10,000 रुपया दे रहे हैं,
You have to-
एक ही गलती हुआ है.
एक गलती, whatever it may be, गलती is the गलती.
My lord, only what I understand, my lord. There was a one misunderstanding of the law probably, my lord. My learned colleague says, my lord, it's a pension matter and that's a succession matter. So therefore, my lord, and somebody has drafted the
You should have
petition.
disclosed all these facts.
My lord, that I understand. I bowed down.
Then the learned single judge would have taken a decision.
I bowed down that, my
That's
lord,
altogether
and
separate thing.
I seek apology
But
for
you
that.
have
my
not,
lord. I accept it, my lord. Yeah, I'm not saying that I have done a good, I'm accepting that, my lord. But only consideration before your lordship is that, my lord, with the succession certificate, I'm not going to get the pension. The FAO which is pending here, that is not going to yield any pensionary
Sir,
benefit. to me.
until that succession proceedings are decided finally, certainly the department can decide who is entitled for family pension, which person is suitable for family pension. Until and unless those proceedings are decided, that is also a reality.
Then we'll approach this for disposal of the FAO faster. So lordship observed that after the
We are not
succession
going to observe,
certificate.
we are simply examining the
No,
validity of
this
the
is the
order
misunderstanding.
of the learned single judge
Hello,
and nothing else.
The person who drafted the petition, he was of the view that since I'm paying only for pension, I did not bother with the mentioning of the
Ultimately, it's
succession
advocate who
certificate.
has drafted the petition and it's
Well,
committed.
your lordship knows some junior colleague of mine, my lord. So that's a mistake. I accept it, my lord. I seek apology also for that. Again.
When you will reduce the cost, okay, but then you have to give up your challenge to the judgment of the learned single judge on merits.
Hello.
You have to give up your challenge to the order of the learned single judge on merits. You simply observe that since you are giving up and the appellant is a poor lady, therefore we are reducing the costs.
My lord, on behalf of the petitioner, my lord, petitioner, I think, my lord, she is very poor, my lord, she should
Although
not
it may
pay.
be poor, but she has to pay
That's why
some cost, some cost.
And as regard, my lord, merits of the case, my lord, only my apprehension is this.
Sir, if you are arguing on
No, no,
merits,
not
then we'll
merits.
deal with the matter on
Regarding-
merits also.
regarding
Then
that
we
fact.
have to deal with all these facts that why you not disclose this. And it seems
no.
that
What-
looking to these facts,
What I'm submitting, my lord, after the disposal of the
can't,
FAO, I may I may go for this pensionary benefit. I may seek for pension.
that is always there.
That
That is always there. There is no question of making any observation for that.
That will be. That will be.
So how much cost do you propose?
My lord, I leave it to your lordship. My learned colleague is going to pay only. The poor petitioner, my lord, your lordship, I have paid.
So the poor petitioner and the rich advocate.
Not rich advocate.
Poor petitioner and the rich advocate.
Rich advocates are available elsewhere, my lord. Maybe Rajasthan,
Rich advocates is sitting in front of us all. So,
behind my back.
okay, standing and sitting in front of. Rich advocates are standing and sitting in front of us.
I leave it to you, lordship. My lord, we don't want to bargain here, my lord. But petitioner party, your lordship will just excuse me.
The appellant has to pay a cost of rupees 5,000. The advocate has to pay the 25,000.
Not 25,000. I leave it to your lordship. It should not be more than 10,000. Both ultimately petitioner's cost also have to be paid by the advocate only.
So
We cannot
that we don't know. Even the advocate can charge from
Well, this
the
petitioner-
appellant also. Give this cost because your case, that case belongs to you.
No, the petitioner,
always there.
I will not hold the petitioner as guilty. The petitioner doesn't know anything about it. She is very poor lady, my lord, whose husband died in the year 2011 with 9 children. 9 children. My lord, what I was saying, my lord, petitioner's husband died in the year 2011, leaving 9 children to her. And she is, my lord, that 4 lakh she got it after
Out of
about,
these 9 children, how many adult children she is having?
that is another aspect of it.
That is
details
another
I don't know.
aspect. Almost all the children might have been, they all are adult.
No, I'm saying, my lord, that
9 children, certainly she is not,
and
yes, she has to pay for grandchildren, I don't know. But,
service book.
so far as regarding this 9 children, all must have been attained their majority and they are earning somewhere.
Maybe, my lord, I'll have to ask for the details.
This writ appeal is filed by the appellant being agreed with the appellant being agreed with the order dated 7232/2021. Whereby the learned single judge has dismissed the writ petition filed on behalf of the appellant number 1. Essentially for the reason that the appellant has abused the process of the court and has imposed a cost of rupees 25,000 upon the appellant number 1 as well as the advocate appearing on behalf of the appellant number 1. Stop. The appeal is filed on behalf of the appellant who has filed the writ petition and by the advocate who represented the appellant before the learned single judge. Stop. Having argued the matter for quite some time on merits, and senior counsel Mr. So has submitted that he does not want to press this appeal, however, has prayed that the cost imposed by the learned single judge while dismissing the writ petition upon the appellant number 1 and the appellant number 2 be reduced. It is submitted by the learned counsel for the appellant that the appellant number 1 is a poor lady, poor and illiterate lady, and she had no intention to mislead the court. And therefore, the cost imposed upon her by the learned single judge be reduced. Full stop. It is also submitted by the learned counsel for the appellant that the respondent number 2 has failed to disclose the facts regarding the pendency of the dispute in relation to the succession certificate of the deceased employee under a bona fide impression that the said matter is distinct from the prayer made in the writ petition on behalf of the appellant for grant of family pension. Full stop. It is submitted that the learned counsel of the appellant has frankly admitted that there was mistake on the part of the advocate but has submitted that the advocate has no intention to abuse the process of the court. Stop. Having heard the learned counsel for the appellant and taking into consideration the facts and circumstances of the case, without going into the merits of the case, we dispose of this writ appeal while modifying the order of imposing cost of rupees 25,000 each upon the petitioner and upon the appellant number 1 and the appellant number 2. And it is ordered that the appellant number 1 shall pay a cost of rupees 5,000. There shall is modified that a cost of rupees 5,000 is imposed upon the appellant number 1 and a cost of rupees 10,000 is imposed upon Shri S.C. Biswas, advocate. Cost to be paid in the name of the Guwahati High Court Bar Association Welfare Fund within a period of
Next week.
within a period of 10 days from today. With these, with this above modification, the appeal, writ appeal is disposed of.
Item 23.
Number 8 weeks.
Item 24.
May please, Your Lordship. My lord, the central government has made certain legislations, benevolent legislations, namely by the postgraduate Indira Gandhi scholarship for single girls, postgraduate scholarship for professional courses for scheduled caste, scheduled tribes, and Rajiv Gandhi National.
When these persons who are entitled for this scholarship.
Yes,
has
my lord.
approached
That Your Lordship will see at page 6,
six what?
page 8, sorry, my lord. Para 8.
Yeah.
My lord, and also my lord, para 5, my lord. Your Lordship can see that.
Yeah.
My lord, then Your Lordship will straight go to
Para 5, what do
para-
you want to?
para 5, the name of the students or the awardees whose
That's
name
right.
appears.
When these awardees approached the concerned bank or the University Grants Commission for the disbursement of
My-
the
my
scholarship, and when it was refused,
My lord,
there is nothing on record.
they went to the Canada Bank, my lord. And
When, sir, and where is that? That the Canada Bank is not providing them this. Where is
Yes.
that?
I,
You simply said, I have been told by whom? And all these persons, sir, none of these persons, except few of them,
my lord,
belong to state of Assam. Sir, you have generalized this, all this UGC list you have filed along with this, that these are the persons to whom the scholarship is awarded,
my lord.
and all of them has not been granted somewhere. From where we get this fact, sir? Out of these 100 and these 200 persons, how many persons have not been granted?
All India contest, my lord. It is
all India contest. So your lordship will kindly see paragraph, page 27. I have indicated there that they have sat in the examination. They have been selected in 14th August 2019. And the persons who approached this foundation is serial number 3, 8, 9, 10, 11, some of these my lord. These are the persons. My lord, from 2019, my lord, till 2025, the bank, when we approach there, they say that
Sir, you have to, there are several things.
Madam.
These are the instructions for filing public interest litigation. There, this rule 10 of the rules of 2011
yes, madam.
specifically says a specific government in para number 3 of the writ petition is specifying the class of persons for whose benefit the petition has been filed and as to how such persons are incapable of accessing the court themselves. You have to mention it.
Madam.
And your, this foundation is registered only in the year 2023. And now you have taken this matter within a period of 1 year. What are your activities? What action you have done? Para number of rule 10.
My lord, page 19,
It's very
para
vague
25.
petition, sir. Very vague petition without there being any on which date the person has applied for that, when it was refused. You have simply said they have not.
Date of court, my lord, in para 25, you will also see.
The petitioner came to know that the Industry Grants Commission, though migrated the dispersal of so and so to the persons of disabilities scheme from Canada will be effect from itna to the institution to upload the joining report for dispersal of scholarship amount. The same has been not been implemented till date. What is the information that by not allowing uploading the required documents and thus not dispersing the scholarship award, the respondents are depriving the beneficiary awardees from their entitled right and under government sponsored schemes. Sir, what are the details to whom it has been denied? How many persons were granted this scholarship? How many persons have not been granted this scholarship? Without there being detail, it's simply you have uploaded
correct,
a
madam.
list from this petitioner has uploaded a list from the website of the Industry Grant Commission that these are the persons and these persons are not getting this scholarship. From where the details, sir? From where we got all these details? After all, it's a public interest petition.
My lord.
You have to mention how many persons have got this scholarship, how many persons have not got this scholarship. There must be some details.
Your
Without there
lordship,
being, we
my
can't.
lord, I understood your lordship's mind. So,
And sir, none of the person here in this, how you are
I'm-
aware about all this? This is the 14th of August 2019.
my lord,
The scholarship was to be dispersed within 24 months. Whether it has been dispersed or not, out of these 200 persons, how many persons were are in receipt of that scholarship? How many persons are not in?
of
receipt
course, my lord, that is correct. Only one thing I want to impress upon your lordship is that the persons whom I have mentioned and who have approached us that we have not received the,
When they
and so
approach the.
they were
when it
within,
was- It's,
3 to 10, 3 to 11, my lord.
yeah.
So 3 to 11, if they are not getting and somebody other getting, that is the, and we do not know who has got it. So if your
You have
lordship,
to mention it, sir, otherwise we can't issue a direction that all the persons have not got without there being any details about that. How can we consider that? Simply because you have said these are the list of the beneficiaries and they are not getting the pension. How many persons are not getting the pension? When they applied for it, when they
my
approached
lord,
the.
these people,
In this.
they are very, my lord, belongs to the economically and
And
socially
how
backward.
these persons are not capable to approach the court for this purpose, sir?
They have not. They have approached the foundation and this foundation works for the.
Sir, your foundation
My lord.
Sorry to say, sir, your foundation is situated in Nogam.
Yes, my lord.
And the persons which you have annexed the list is for whole of the state, south to north, and even not a single institution of Assam is included in it. Not a single institution. I've gone through these 200 persons
My
list.
lord.
Sir, it's of Rajasthan, it's of Magadha University, Bihar, Pondicherry University, JNU University, University of Hyderabad, don't know. Jadavpur University,
My lord,
Mahatma Gandhi,
if I can say so, my lord,
Vidyapeeth.
this part of my lord
very-
country, these
Sorry to
students
say,
belongs
sir.
to very poor
Sorry
and
to say, it's very easy
so,
to
my lord,
download a list from the UGC website that these are the persons whom the scholarship was granted. And these persons are not getting the scholarship. Where are the details, sir? Out of these 200 persons, such a vague petition,
anyway, my lord, your lordship will grant me some time so that I can incorporate the things, my lord.
consult for the petitioner pays some time to furnish better particulars in support of his claims. That in support of the claim of the petitioner that the and this is the provisional selected candidates. That is not final even.
My lord.
That is a provisional selected candidates. This list is not final.
That will be finalized when when the people has uploaded their documents and the universities and
Sir,
institutions
where
where
is the final list? Out of these 200 person,
Right.
ultimately. how
all right,
many
my lord,
persons
I
were
understood your lordship mind. I will try to give those information.
better particulars in better particular. Non-counsel for the petitioner pays some time to furnish better particulars in support of his claim made in the PIL petition. Just after summer vacation.
Obliged.
Item 26.
Yes. Last occasion you.
Yes,
got
no,
some time.
I have received instruction.
Yeah, what instructions?
Instruction, my lord, the land mortgaged by him, mortgaged by the mortgagee is not under his possession. This is a different land. That is why
Not is in possession me.
this is not his land. The mortgagee who is, the land mortgaged by the mortgagee is not the owner.
So who is the owner?
The owner is somebody else. Lordship will find in that instruction. The defined land he has mortgaged, my lord. This is
Ultimately,
the.
you are not supposed to look the owner, you have to take the position of the
Because,
property in whose position it may be.
My lord, the owner, original pottadar is someone else. The person who mortgaged the land, he purchased some land from him, original pottadar. But in the sale deed, the particular land is not mentioned. That is why the land which was mortgaged by the mortgagee is under possession of legal heirs of original owners. Since
Is it a
long.
Case of fraud or what?
Maybe, my lord, I cannot say it's a fraud, but the financial, they could have, my lord, they verified the land when the mortgagee mortgaged the land.
The prima facie the case is there, which they have given a dark number actually. The dark number is in the names only. There is no thought to it. But while the cycle officer went to check, he found some another person staying over there. That is only the thing.
Then you have to clarify this situation.
But it is not mentioned in the
It's not
petition.
that they are not,
No,
they have not acted on it. You can't issue a mandamus that go and
No,
take
it's
the
a-
position of that.
Yesterday only, I received a call from this one. Yesterday only, it was known to me. So I said, okay, fine. If your feeling is,
You approach them. withdraw this petition.
The order has to be changed.
Whatever
what is
it
it?
may be, you approve that. Withdraw this.
Okay, I will do it.
And concept of the petitioner, wants to withdraw this petition with liberty to approach the concerned officer for appropriate relief. Dismiss is withdrawn.
I'm deeply aware.
Item 27.
My lord, I have annexed the last orders, my lord. The petition, my lord, WPC number 2596 of 2024 is at page 146, my lord.
146.
My lord. My lord has issued notice and fixed on 24/6/2024. My lord. Along with that, this can come up also. My lord.
List on 24/6/2024 along with writ petition number 2163/2024.
Obliged.
Item 28.
Yes.
Lordship, in this case, Lordship, the issue involved is that petitioners who are not BSc nursing, Lordship, they are claiming grade pay at par with the BSc nursing. Lordship, on last date, your Lordship directed me to obtain instruction. And my instruction, it's dated 21st of May 2024. It states, Lordship, the department was requested to take policy decision and resubmit the proposal. But no such proposal has yet been received in the finance department. Lord.
The medical department,
Yes, health department. Lord.
health department. They will admit it, will hear it.
The medical department already admitted, my lord.
Hmm?
Medical department already admitted by filing an affidavit.
That's right, but the finance department is objecting to it. But they are saying that since there is a difference between the qualification and therefore the same relief cannot be granted to them. They will admit it and decide it in accordance with. They will admit this writ petition and will decide it on that.
This is pending last 4 years, my lord. Now, my lord, new ROP will become, my lord.
Having heard the concept of the parties, we deem it appropriate to admit the petition, hence admits no need to issue notice that parties are already represented. This is the matter for hearing in the due course.
Obliged.
Diploma.
Item 29.
Well, we have preferred this writ appeal against the order, judgment and order that that lot of people will find at page 144. Lord.
Was earlier argued, I think.
Well, against the same judgment, the respondent number one, he has also prepared an appeal that he should be given that lordship was dismissed, no?
Yes,
The
we have already decided.
lordship
Where is
that
that judgment?
that judgment lordship is
We already accomplished it.
correct, lordship. That has been dismissed. The claim of the respondent was that
That was the details.
well, rate appeal 250 of 2023, well,
250 of 2020.
250.
Decided on.
Well, can you give me a minute, Malad? This was something.
29th May. 29th May.
Lordship. 29/5/24, Malad.
The order. Is that part of your weekend? That has become final.
Yes.
But here, Malad, basically on two grounds we have preferred this appeal. Kindly come to ground C and D at page 20, Malad.
Now,
Ground number C and D at page 20, Malad.
20.
20 of the writ appeal, Malad. But now the respondent number one, he is claiming that he should be given the benefit of seniority from the date of his initial entry. But ground C, Malad, that for that while passing the impugned judgment dated 18/11/2022, the learned single judge failed to appreciate that the respondent number one, who remained absent from service from 31/7/2004 till 2013, did not gain any service experience in the post owing to his absence. In such a situation, if the benefit of service continuity is given to the respondent number one along with the other employees who are serving in that particular cadre continuously, it would create a chaotic situation and hamper the morale of the employees. And now if he gains the seniority, then he has to be promoted to the next cadre also. But as per the service rule, Malad, a particular period has to be spent by the officer concerned in the feeder cadre. He has not served.
By a person?
An officer in the feeder cadre has to serve for a particular period like 5 years or 6 years for his promotion to the next cadre. If the petitioner is given the seniority for that period when he was not there in service from 2004 till 2013, so he has not served. So if seniority is given, no experience, and if he is given promotion to the higher the cadre, then it will be a difficult situation for us.
You can justify your action
Malad,
of treating his entire period as ISA on You just specify this, that's all.
Yes, yes. Well, kindly see, well, at page 141, there is an order. On
141.
141, annexure D1. Annexure D and D1, I am taking your lordship to page 143, my lord. Annexure D1. This is the order, my lord, by which the governor of Assam is pleased to revoke the suspension order issued by this department by notification number so and so, dated 29/3/2006 in respect of Sri Debashish Pujari so and so, with immediate effect, the period of suspension along with the period of unauthorized absence in respect of Debashish Pujari shall be treated as dies non for all purposes. But this has not been put to challenge at any moment, my lord. This has not been challenged. This was not challenged, my lord, and my lord, subsequently in the year 2016.
This was very much under challenge.
No, my lord.
In the writ petition itself.
No. If lord, my lord, they filed a
Judgment.
no, my lord, in the writ petition challenges against the speaking order at page 108.
Everything much is there.
They filed a representation where
He was agreed by the action of the respondent department of treating his the absence period as dies or non. This is what the issue before the learned single judge.
my lord, kindly, if lordship kindly comes to page, my lord, the prayer in the writ petition, my lord, I have annexed the writ petition at page 48, my lord. He has, my lord, kindly see, my lord. First prayer is at page 49, my lord, internal page 22, to set aside and quash the impugned speaking order, that is at page 108. Second, my lord, the set aside and quash the final inter se seniority list published by notification number 24/10/2016, showing the notification that is so and so, to the extent of showing the date of appointment, date of joining in PWD of the petitioner as 2013 instead of 2003 with all consequential benefits. So for the first time in that 2016, when his name was put there, he made a representation, and ultimately that representation was directed to be considered, and the speaking order was eventually passed in 2018.
Mr. Nath,
Lordship.
just show us this FR number 18.
Lordship.
And follow under refer the entire service period is then forfeited by the judicial department, meaning the writ petition is instituted. So the petitioner has filed this writ petition agreed by this section only.
Yes.
But
This is what the petition is.
but 1st of October 2013, the order was passed. He rejoined the service in 2013.
That facts are not in dispute.
Well, he never
Those
challenged this
facts
order.
are not in dispute.
Well, he never challenged. He
Sir, kindly
Lordship.
come to para number 7 of the impugned judge.
Lordship.
In such circumstances, writ petition number 7317
Lordship.
was instituted by the petitioner, which was given a final consideration by the order wherein there was a direction to the commissioner secretary to give considered representative that may be submitted to the consequent thereto. The order dated was passed. Amongst the others, it has been provided and advised by the personal department, and upon considering the prayers of the petitioner taking a humanitarian approach, the tribunal decided to conclude the department proceedings against by revoking the suspension order dated so and so, and to treat the entire period of Dyson for all purpose under FR 18.
Lordship.
And the entire service will stand for the advice by the so and so, so and so.
Lordship.
This is what the challenge.
Well, this was while considering the representation pursuant to the honorable court order. But originally the order was issued in the year 2012, October 2012 at page 143. Well, this was never challenged. Well, at page 143, it is there. Well, when his name was placed at a particular place in the gradation list, he filed a representation. Then he initiated the writ petition, which is WPC number 7317 of 2017 in the year 2017. So from my respectful submission is since the month of October 2013 and he's resigning in 2013, he was not at all aggrieved. He never challenged this, and only against the gradation list, inter-se seniority list published in the year 2016, he has ventilated a grievance that his name should be placed at a particular place, and accordingly, the page 108, the speaking order was passed. But again, Lordship, at annexure D, page 141, kindly see, Lord.
Yes.
Made fusion also. Earlier, there was an order, if your lordship would kindly come to page 103.
Yeah.
Starts it case 75 ne 10. 102, my lord.
102, yeah.
Yes, and please come to page 103.
Yeah.
The second para. This writ petition is
Taken up for disposal.
taken up for disposal at the motion stage itself. And the prayer of the petitioner is that he insists only for a limited relief, that his representation filed before the commissioner and secretary to the government of Assam in PWE, wherein he has ventilated his grievance may given a due consideration. My lord will kindly come to the next page, para 4. By order dated 9/11/12, the order of suspension was revoked. Thereafter, upon certain undertaking given by the petitioner, as regards his claim for wages, the respondent authority by order dated 9/11/12 had reinstated the petitioner and posted him as assistant engineer, etc., etc., etc. Well, that order of October 1st, 2012, even in the earlier round of litigation, they have not brought on record. This is for the first time they are bringing on record. And this is the order 9/11/22, whereby my suspension order was revoked. In fact, in the affidavit file, they have never brought on record this document. They brought on record this 9/11/12.
Yeah.
Now, my lord, coming to the facts of the case. Now, end of the day, my lord, they have invoked the principle of dies non. Now, what is the effect of, application of the principle of dies non? The period for which is treated as dies non, that will neither be counted for any purpose, nor it will be treated, nor it will be a case where the master-servant relationship will cease. If that be so, the learned single judge's view is absolutely correct. The meaning of dies non, which the state respondents have understood, is not correct. In fact, my lord, our High Court judgment is there is a clear-cut authority on this point. I think GLR 2014 1 GLR 175. Though the learned single judge has not referred to the judgment, but the purport is same. GLR I'm sorry, my lord, one copy. Lordship should kindly come to paragraph 29 and 30. Oh,
Yes.
there is another copy, Miller. Para 29. In service law, the expression dies non is widely used by the disciplinary authorities to denote unauthorized absence by delinquent employee. Dies non is used to define a period which is neither counted as a part of service nor considered as a break in service. A period of service can be marked as dies non if employee is absent without proper permission. The employee, though on duty, lives without prior permission, and employee is in office but refuses to perform duties. In other words, this must be a case of willful and unauthorized absence from work. In such a case, the days on which work is not performed may be treated as dies non based on the principle of no work, no pay. Such a course of action may be resorted to without prejudice to disciplinary action the competent authority may contemplate. Therefore, in service law, dies non means a day or a period which cannot be treated as spent on duty for any purpose. Though it does not constitute break in service, but such day or period treated as dies non would not qualify as a part of employee's service for pensionary benefit or increment. In other words, my lord, the period as indicated in the show cause notice, which according to them, my lord, we were out of service, that period cannot be counted for any purpose. But it will not lead to, my lord, a break in service. The master-servant relationship continues. Now, by the impugn order, the state would like to say that now, since when I joined on 8/12/30, 8/2/13, my service will be counted from that date. That is on the wrong understanding of the principle. Now, if your lordship would kindly come to the order at page 108. The operative portion is at 109. The third subpara. Whereas the department moved the file to the personnel and judicial department for their views on the matter, on going through the views offered by the both department, the disciplinary authority found that going abroad and overstaying without permission of the competent authority are violation of the established হয় বাকি চাকৰি সোমাবই নোৱাৰো কেনে আপোনাৰ মতে যদি মিনিং ধৰি আছে
What is the criteria for promotion on the higher post? Not only the seniority. The merit and seniority must be there.
But these are all merit-based promotions, my lord. Only that period of service will work as a qualifying period.
Yes, my lord.
Qualifying service.
Now he is assistant engineer, he will go to assistant AEE and that is 5 years, my lord. Minimum service, minimum period of services.
That's another thing.
Not it.
Merit comes seniority.
And then it is merit.
Merit. Then
if in merit I get it, I
don't give the promotion to him. That since he was absent at his.
Well, his grievance started when he was not put in the particular place in the seniority list.
But ultimately, whatever it be, that's why only because his grievance started because you assign him the date of appointment of 2013 when he was reinstated. So he came with this assignment is not proper. Then you came with the pillies of Dyson on was there.
Yes, my lord. But our
Dyson on means not in break in service.
Yes. It is not,
He is
but
not
this,
entitled for pay or other benefits such as pensionary benefits, increments. Yes.
even the benefit of seniority will not, also not he will get.
So that is not.
He will not get. Well,
You show us any law.
I'll
The period, the period of service treated as Dyson on is not entitled for seniority also. When there is no break in service, how can you say that?
the learned single judge has said that the employer-employee relation remains and the continuity is there and that is why they are claiming seniority. I'll just place reliance on.
Don't give. That's altogether different.
I'll place reliance on a decision of this Apex Court, Malad. There in 2010, 12 SCC 737, Malad. I have given the citation, Malad. There, Malad, the period has been the decision of Dyson 2010, 12 SCC 737.
Yeah.
Malad. It's a small judgment, Malad. I'll just read, Malad. Otherwise, the paragraph is, Malad, 9 to 11. I have given the book, Malad.
Read it.
Lordship. The para 10, we direct the respondent herein to reinstate into service, provided they have been their issue was matriculation and they provided they have passed matriculation examination from any recognized institute and procedure and produce the certificate at the time of joining in the service. In these appeals, the respondent will not be entitled to any pay and allowances with effect from the date of their dismissal from service till their joining on the principle of no work, no pay. They will not ask for any claim with regard to pay, allowances, seniority, promotion for this period.
Show us that the periods of Dyson on cannot be counted for the purpose of granting seniority.
Para-
Show us any law.
Para 11, Malad, para 11.
Para 11.
Yes, yes, Malad. The court,
This is in the facts and circumstances of the case where they have not obtained this degree of some, whatever it may be. How can it be? treated
Malad,
as-
Malad, kindly say, Malad, that they will not ask for any claim with regard to pay and allowances, seniority and promotion for this period. And the period in question will be
This is under Article 140.
period.
Sir, this, in relation to facts and circumstances of that case only.
Malad, here also they were.
Sir, show us any law that wherever the service period of the employee is treated as Dyson on, the same cannot be counted for the purpose of granting him seniority. Show us the any law.
Seniority, logic.
Show us any law.
But one, I find this here, the honorable court has said that they will also not get seniority. The period will be treated as dias-non. The last sentence,
Sir, where is that?
that the last sentence, the period in question will be treated as dias-non. Para 11. Honorable court said that they will not ask for any claim with regard to pay and allowances, seniority and promotion for this period. The period in question will be treated as dias-non.
In the facts and circumstances.
My lord will
of
kindly
this-
read para 7 of
Yes,
the
yes.
judgment.
No, para 7, there are two sets of claim, Lord, in respect of in fact, the seniority claim they are not entitled to
So
the
there is
seniority.
there is a, para 7 says there is a concession on the part of the advocate.
But
It is not the law. Mr. Nath, please don't try to, if you have any other law, show us, otherwise no.
I have got two Supreme Court cases, my lord. Other one is 2022 SCC online, my lord.
Okay, sure.
Logic. There in those two cases, court has observed that they will also not get seniority. That is what I find.
Sir, you show us any law which says that the period declared as a Dyson on cannot be counted for the purpose of seniority. That's all plain and simple. You show us any law.
My lord, I got those two decisions. Where,
Those decisions are not of any help of.
my lord, otherwise I have tried my best. I did not.
Net concept of the petitioner,
But the other decision, just for my satisfaction, I'm referring to that one.
Admit this petition and admit no need to issue notices to the respondents. After, in the facts and circumstances of the case, we don't find any case for grant of stay. Hence is there any prayer for stay?
But we have prayed for it.
You prayed?
Yes, my lord. Page 22, my lord.
Grant of any stay, hence the prayer for staying the impugned judgment is declined. List in due course.
Section 64, that is pending before the Honorable Supreme Court.
Yeah.
Well, this is the fourth time this matter has been listed, and my learned friend says the same thing. And I have been again and again repeating that, my lord, this is a matter where I am not challenging the constitutional validity of section 16(4). What is pending before the Honorable Supreme Court is challenge to the constitutional validity of section 16(4). I am only on the interpretation, my lord. And my lord, the short issue in this matter is that, my lord, section 16(4) says that if I cannot take the credit, my lord, kindly have a look at section 16(4) for once. Central Goods and Service Tax, CGS.
Have you filed the reply?
No.
Why?
See, we have to yet to get, because Lordship, the law point is involved.
So law point is that what the concept of the petitioner is saying that they are not challenging the validity of this section 16(4). They are simply seeking an interpretation of this provision.
Then Lordship, they come against a order passed by the Eastern Commission appeal license to the under section 107 appeal license.
Sir, see, whatever objection you have, file a written objection to that. If you are objecting to this maintainability of the petition, file that.
My lord, on maintainability, I have already argued, my lord. Your lordship has admitted the petition after, my lord, the rejecting the arguments on maintainability.
Stay is already, no, Lordship, there was no argument on that point, Lordship.
That was argued, my lord. I can again argue. There is no problem, my lord. On maintainability also, I can argue.
No, in fact, we have not admitted the petition yet.
Yes, Lord.
But they have been directed to file a.
Yeah, last time
like-
the secondary.
Notice has been issued.
Last time, you took this excuse, the officers are on election duty, therefore reply could not be filed. Now, what's the?
That is under preparation, Lordship.
Huh?
The reply is under preparation, we require some more time, Lordship.
Please try to understand. Simply, we have already passed the interim stay order.
Right, but what I request your lordship is that there is no dispute of fact in this matter. There is no dispute of fact. Kindly just for a moment, kindly have a look at section 16.441.
Okay, fine. Yes.
Well, it says a registered person shall not be entitled to take input tax credit. My lord, your lordship has section 16,
Yeah.
subsection 4. A registered person shall not be entitled to take input tax credit in respect of any invoice or debit note for supply of goods or services or both after the 30th day of the November following the end of the financial year to which such invoice or debit note pertains or furnishing of the relevant annual return, whichever is earlier.
No. Just invoke debit credit so and so after the due date for finishing the return under section 39 for the month of September.
Yeah, my lord, that was at that point of time. My lord, subsequently it has been amended to 30th day of November. My lord, kindly refer to whatever section your lordship is reading, 30th day of September 2024.
Return under section 39 for month of September following the end of financial year to which such invoice or debit note pertains to furnishing the relevant annual, whichever is earlier.
Yes, my lord. So what it says is that I cannot take credit. It refers to the word I cannot take credit post the date which is mentioned here. That is the
30th of September.
30th of September. My lord, there is no dispute about the fact that I filed my return. But there is no, my lord, the so-called notice or the order which has been passed, it does not say that I did not take the credit. It simply, my lord, it refers to my return filing date from the portal. My lord, the return is filed online. They refer to that this is the date you have filed the return. Since there is a delay in filing of the return, so you are not entitled to take the credit. Now, my lord, my return has been accepted on payment of the late fees. So, my lord, they have regularized my delayed filing of the return. And there are, my lord, my only submission, my lord, there are 3-4, my lord, legal proposition, my lord, but first and foremost, my lord, and it is well settled by the judgment of the Honorable Supreme Court in the context of GST. Even though, my lord, the issue was different. But here, my lord, why, my lord, this kind of order is being passed? Because there is a press release which has been issued, which says that if anybody files return after this particular date, then the ITC becomes time barred. So that press release, that particular paragraph, which says so, is also challenged here. So, my lord, my learned friend saying that I have an alternate remedy. I do not have any alternate remedy. My lord, the officer's hands are tied by the press release, which says that if you delayed in filing of the return, you can't avail the credit. My humble submission is that, my lord, the credit is not taken through the return. It is reflected in the return. But the credit is first taken in the books of account. So, my lord, while the officer, before passing the order, he should have called for the records, my books of accounts, whether I have taken the credit in my books of accounts within that particular date. If on the analysis of my books of account, it is found that no, I have not taken the credit, then, my lord, he could have debarred me from taking the credit. But that is not the case, my lord. The only simple case is that I have delayed in filing of the return beyond that date which is prescribed here. And, my lord, it does not talk about that. Suppose my return for the month of March 2018, which I filed beyond this due date. My lord, it had to be specifically mentioned that if I delay in filing of my return, then I will be debarred from taking the credit.
Once they have taken the late fees and condoned the delay.
Condone the delay, my lord. There is a judgment of the Honorable Calcutta High Court, my lord. There are judgments of the Supreme Court also in the context of Income Tax Act. And, my lord, in the context of the Central Excise, there was a similar provision is existed where it said that beyond 6 months, you cannot take the credit. And my lord, at that point of time, there used to be a specific record. Now you can maintain record on your own. There used to be a specific record, RG23A Part 1, RG23A Part 2. RG23A Part 1 pertained to my lord, the accounting of the quantitative my lord, accounting of the goods received. And Part 2 related to the taking of the credit.
Fine.
So in Gujarat High Court as well as Madhya Pradesh High Court said that just because I am taking the credit in my Part 2 beyond that 6 months, I cannot be disentitled to taking of the credit because my right has accrued on the date I received the good.
They already interpreted this 16(4). The Gujarat High Court.
Yes. No, Gujarat High Court and the Madhya Pradesh High Court judgment is in the context of central excise. When 6 month time limit was there, my lord.
Okay.
And my lord, there is a judgment of the Honorable Supreme Court, my lord, my submission which I am making, kindly give the comparison. But kindly have a look at para 30, page 9. Well, the judgment starts from page 1 of the compilation, Union of India versus Bharti Airtel Limited.
Yes.
Well, before I start reading the paragraph, my lord, I just give a brief background of what was the dispute in this matter. But the dispute was that the SSC filed his return for July 2017, as soon as the GST was introduced. They did not claim the credit in the return. And they sought revision of that return saying that I could not take the credit because there was no GSTRA operational on the portal. I could not have a look at the figure from the portal. So that is why I was debarred from credit. So it is your fault because of which I could not take the credit. So you now allow me to revise the return. So it is in this background, my lord, the judgment was passed, my lord. Now,
and the authorities has refused to accept that.
Accept that. Now, what Supreme Court says, my lord, kindly have a look at from para 33 onwards, my lord,
Yes.
page 9.
Yes.
As per the scheme of the 2017 Act, it is noticed that the registered person is obliged to do self-assessment of ITC. Self-assessment of ITC, my lord. Reckon its eligibility to ITC and of OTL. OTL means, my lord, output tax liability. Including the balance amount lying in the cash or credit ledger, primarily on the basis of his office records and books of accounts required to be statutorily preserved and updated from time to time. So what it says that, first, my lord, it is self-assessment. Second, I have to take the credit primarily on the basis of my office records and books of accounts required to be statutorily preserved and updated from time to time.
Fine.
That he could do even without the common electronic portal as was being done in the past till recently pre-GST regime. As regards liability to pay OTL, that is on the basis of transactions effected during the relevant period giving rise to taxable event, the supply of goods and services becomes taxable, in respect of which the registered person is obliged to maintain agreement, invoices, challans, and books of accounts, which can be maintained manually, electronically. The common portal is only a facilitator. My lord, this is very important. Common portal is only a facilitator to feed. So feeding the information about my ITC or to retrieve such information, and need not be the primary force for doing self-assessment. The primary source is in the forms of agreements, invoices, challans, receipt of goods and services, and books of accounts, which are maintained by the SSC manually, electronically. These are not within the control of tax authorities. This was the arrangement even in the pre-GST regime, while discharging the obligation under the concerned legislation. The position is no different in the post-GST regime, both in the matter of doing self-assessment and regarding dealing with the eligibility to ITC and OTL. Indeed, that the self-assessment and declaration would be anyway subject to verification by the tax authorities. The role of tax authority would come at the time of verification of declaration and return submitted filed by the registered person. So, my lord, what it says is that I take credit on the basis of my books of accounts and my primarily maintained records, invoices, etc. Not on the basis of the portal. The portal is only a facilitator. My lord, next it goes on to say section 16 of the 2017 Act deals with the eligibility of the registered person to take credit of input tax charged on any goods or services or bought to him which are used or intended to be used in the course or furtherance of his business. The input tax credit is additionally recorded in the electronic credit ledger of such person. So, my lord, the electronic credit ledger is additionally recorded. So, what it says is that
Another entry.
It is
another entry, additional.
Additional entry. Additionally recorded, my lord. How it is additionally recorded, my lord? That is by GSTR 3B return.
Okay.
It goes to the electronic credit ledger by virtue of filing the GSTR 3B return. That is the only process of filing. Even though, my lord, when the GST law was envisaged, it was conceptualized that there will be a GSTR 1 return, there will be a GSTR 2 return, there will be a GSTR 3 return. GSTR 1 return will be a sales return. That means I sell the goods to B. Now B, so it was supposed to be done within 10th of the month.
Okay.
Now what B will do on the basis of my various suppliers who have sold goods to me, I will see on the portal GSTR 2A. GSTR 2A will automatically pop up in my portal, which did not pop up in this particular case. But that is why it went up to the Supreme Court. So GSTR 2A will pop up. Now I will, on that basis, GSTR 2A, I will reconcile it with my books of accounts. If it is reconciled with GSTR 2A, I will file GSTR 2. Once I file GSTR 2, it will go to the electronic credit ledger. Thereafter, my lord, I will file, and that will happen within 15th of the month. Then GSTR 3B will be filed. GSTR 3, final return, a combination of 1 and 2. 1 and 2 information will automatically pop up in GSTR 3, and I will file my final return. Now, at the time of filing of the final return, if suppose there is an error with respect to input tax or output tax, I will rectify that in GSTR 3. I will show that, my lord, by virtue of Rule 61, that provision was there. Now, when GST law came into being, there was a hue and cry all over the country that what business entity will, how they will do the business. I will 10th of the month, I will file GSTR 1, then GSTR 2, then GSTR 3. So the government felt the pressure and they said, okay, GSTR 2 will switch off. GSTR 3 also had to be invoice wise, and all of it had to be invoice wise. Considering the voluminous data being involved, the government felt it necessary that we will have a summary return where there will be no invoice wise detail. Just I give my total turnover, total purchases, total ITC, declare my input output, and pay my tax on my own, which is GSTR 3B. There was a GST council meeting which said that it will remain operational only for 2 months.
Okay.
Now for 2.5 years, my lord, they continued with this arrangement. They said that GSTR 3 we will notify subsequently. We will notify. They never notified. In the meanwhile, my lord, when they felt that this is not going to work finally, they said that now GSTR 3B will be the final return. They never notified GSTR 3. They never notified GSTR 2 also. And had they notified GSTR 3, my lord, the provision was, the rules itself said that if there is something left out in GSTR 3B, then I can take that credit in GSTR 3. GSTR 3 was supposed to be the final return, which was never notified. And by the time my GSTR 3B was filed, which is the date they are talking about, it was not supposed to be the final return. So had they notified GSTR 3, this section 16.4 problem would have never arose, at least as far I am concerned, because I would have complied by filing GSTR 3 well within the time of section 16.4 also, but they never notified GSTR 3. And I had to rely upon GSTR 3B, which I suddenly come to know that I am at a dead end. because the government itself never notified. And since GSTR 2 was never notified, this GSTR 3 became the only mechanism to additionally reflect this data in the portal. So, my lord, in that background, my lord, I again, my lord, go back to this judgment, then my lord, I will make my further submission. So, paragraph 34, section 16 of the 2017 Act deals with the eligibility of the registered person to take credit of input tax charge on any supply of goods or services or both to him, which are used or intended to be used in the course or furtherance of his business. The input tax credit is additionally recorded in the electronic credit ledger of such person under the Act. The electronic credit ledger is defined in section 246 and is referred to in section 49(2) of the 2017 Act, which provides for the manner in which ITC may be availed. Section 41(1) emphasizes that every registered person shall be entitled to take credit of eligible input tax as self-assessed in his return, and such amount shall be credited on a provisional basis to his electronic credit ledger. Then, my lord, as aforesaid, every SSE is under obligation to self-assess the eligible ITC under section 16(1) and 16(2) and credit the same in the electronic credit ledger defined in 246 read with section 49(2) of the 2017 Act. Only thereafter, section 59 steps in, wherein the registered person is obliged to self-assess the taxes payable under the Act and furnish a return for each tax period as specified under 39 of the Act. To put it differently, for submitting return under section 59, my lord, this is very, very important. To put it differently, for submitting return under section 59, it is the registered person who has to undertake necessary measures, including of maintaining books of accounts for the relevant period, either manually or electronically. On the basis of such primary material, self-assessment can be and ought to be done by the SSE about eligibility and availing of ITC and OTL, which is reflected in the periodical return to be filed under 59 of the Act. But this is exactly my submission, my lord.
Yes.
So, my lord, again, for last paragraph 36, section 59 does not make reference to section 39, which deals with furnishing of the returns. But the fact remains that for furnishing of the return, preparatory work has to be done by the SSE himself and is not fully or wholly dependent on the common electronic portal for that purpose. Just a couple of weeks before the relevant period between July and September 2017, the writ petitioner had been doing that exercise, which is expected to continue even under the post-GST regime. The factum of non-operability of Form GSTR 2A, therefore, is a principle taken by the writ petitioner respondent number 1. Indeed, if the stated form was operational, the same would have come handy to the writ petitioner for doing self-assessment regarding eligibility to ITC and availing thereof. But it is a legal excuse given by the writ petitioner respondent number 1 to assail the condition specified in the impugned circular so-and-so regarding the rectification of return submitted manually in Form GSTR 3B for the relevant period. So, my lord, this is my exact submission, my lord. That, my lord, the self-assessment is done on the basis of books of accounts.
Right.
It is additionally recorded and it is only reflected in the periodical return. Subsequent to, my lord, everything which is done in my books of accounts, self-assessment, everything. So, my lord, that exercise has never been done by the concerned officer. And, my lord, I have enclosed a chartered accountant certificate, my lord.
The problem is that now, since you have this submitted your return after the due date, and therefore they are saying that this input tax credit is not available to you.
Not available to me.
Yes. So that they have to now justify that on account of submission of late, this filing of return is not entitled for that input tax credit.
Correct.
And for that, your plea is that since you have accepted my this return,
right,
by charging this late fees,
correct,
and therefore it would be deemed that you have accepted the same and the delay period is condoned.
Correct, my lord.
That is what.
My lord, not only that, my lord, my submission is that their entire basis is incorrect.
Right.
But not only, my lord, that the return has been accepted as, my lord, regularized. My lord, my primary submission is, my lord, that the fact that I took, my lord, I have not violated the condition of section 16(4). That is my primary submission.
The violation of condition in the fact that since you have filed the return after the due date,
right,
that may be treated as a violation.
No, my lord, kindly have a again look at section 16(4), my lord. That is why, my lord, that the judgment says exactly. So, my lord, what I'm trying to distinguish, my lord, kindly have a look at section 16, my lord.
Yes,
Section 16(4).
yes.
A registered person shall not be entitled to take input tax credit.
Yes.
But this is very important. The word used is take.
Take, yeah.
Take. Then, my lord, kindly refer to section 41.
Yes. Claim of input tax is a provisional acceptance thereof.
Well, section 41, availment of input tax credit.
Section 41.
41, my lord, 41.
Claim of input tax credit and provisional acceptance thereof. Section 41.
41, yes, my lord, that is the section.
CGST Act 2017.
Yes, 41. Claim of input tax credit and provisional acceptance thereof.
Yeah. Claim of input tax credit and provisional acceptance thereof.
Yes.
Yeah.
My lord, every registered person shall, subject to such condition and restriction as may be prescribed, be entitled to take in eligible input tax credit as self-assessed in return and shall be credited
On a provisional basis.
to his electronic credit ledger.
Yes. The credit referred to.
My lord, the word used is avail, my lord. The avail the credit of input tax credit, my lord.
Avail, the entitled to take the credit to eligible input tax, not avail.
Yes, every registered person shall, subject to such may be entitled to take the credit of input tax as self-assessed in his return, and such amount shall be credited to on a provisional basis to his electronic credit ledger. So what I'm submitting, my lord, that there are two events. One is that taking of the credit. Then, my lord, subsequently that on the basis of the self-assessment, it refers to the self-assessment. And that self-assessed credit is then, my lord, disclosed in the return. So it is merely, my lord, what is filing of the return? My lord, it is my statement of affairs which is declared to the authorities, my lord.
But sir, coupled with this, if we read this section 41, the 16(4), it speaks that a registered person shall not be entitled to take input cash credit in respect of any invoice, not supply of goods, both after the due date of furnishing the return.
So that is what I'm submitting, my lord, that what my submission, your lordship, is
Yes.
that as per that Supreme Court, what Supreme Court says, that you additionally declare the information which is already available with you in form of invoices and your books of accounts. It is only an additional declaration on the portal. And how that additional declaration takes place? Through filing of the GSTR 3B return. What section 16(4) talks about is not filing of the return. It talks about taking of the credit.
But subject to the condition that this furnishing of the return before the due date.
No, it does not talk about that furnishing of the return, my lord. Kindly read it again, my lord. It does not, that is what I am saying, my lord.
16(4).
My lord, if had that section says that my return, my lord, kindly read it again. A registered person shall not be entitled to take input tax credit in respect of any invoice or debit note for supply of goods or services or both.
After the due date of furnishing the return.
So, my lord, it is saying that I cannot take the credit after due date of furnishing of the return for the month of September. So it is fixing the date. So that the return date which they are talking about is the return filing date for the month of September. So what it is restricting is that I cannot take credit after the due date of the filing of the return for the month of September. Now the due date of filing of the return for the month of September is 20th of October, because it is supposed to be filed 20 days later.
Yes.
So that is the last date which is assigned, that you take credit not beyond this 20th of October. But it does not talk about filing of the return for the previous financial year, my lord. It does not say that you cannot file your return for that period beyond this due date. My lord, kindly have a look. It shall not be entitled to take input tax credit.
Support for that, Mr. Schwab, for that reason, let them file their reply. Because, yes, your argument may be somewhat convincing, but for that reason, let them file their counter. And we, in the meantime, we have already passed.
My lord, what I'm submitting is, my lord, that it is a pure question of law. Ultimately, it has to be argued by my learned friend. If he's not prepared today, he can take time to prepare, my lord. But on affidavit, my lord, nothing new will come out. My lord, my due date, my lord, my return filing date is.
Let them come with the interpretation of what you are saying. Let them come with their counter to that. Without their being, they may argue or they may not argue, but let them come in the black and white. For our understanding the matter, that's the whole thing.
Yes, ma'am.
Yes, you understand better than us, but at least for
No, no,
our
my lord, I
understanding,
don't.
that's why only. Because you are dealing with these matters day in, day out. Mr. Kyle, you have to file the reply. You can't take this excuse. This matter is pending before the Supreme Court when particularly this provision is the validity of the provision is not under challenge and it's only a question of interpretation. File a reply.
And Lordship, if they are not challenging any notification or act, then it will be decided with a single judge because.
You please take these technical objections, whatever you are having in your written argument, and then we'll see to it, sir. Ultimately, it's a tax matter. If the division bench is going to hear you, what's the problem with that?
No, Lordship, about 100 cases are being taken up by the single bench.
Whatever it may be, you file your, whatever the objection may be. Stop.
My lord, this is the, my lord, this is the fourth time, my lord. Let it be the last chance for them.
Sir. We have already noted this. I'm noting this. This on 8/4/2024, Mr. Kyle was granted time to file reply to file the counter to the writ petition by the second week of June 2024. Stop. The counter to the writ petition has not been filed till date. Mr. Kyle has submitted that the question regarding the validity of section 16(4) of the CGST Act 2017 is pending consideration before the Honorable Supreme Court. Full stop. It is noticed that in this petition, the validity of section 16(4) is not under challenge, and the petitioner is seeking interpretation of section 16(4) only. Full stop. Seeking interpretation of section 16(4) only in respect of the press release issued by the GST, by the CGST department. Full stop. Taking into consideration the above fact, we are of the view that the GST department is required to file counter to this petition. Full stop. Last opportunity is granted to Mr. Kyle to file the counter to the writ petition. This petition on 22nd of July, 2024. Full stop. Counter to the writ petition be filed positively by the next date of hearing, while supplying copy of it in advance to the counsel for the petitioner. The interim order passed by this court on 8/4/2024 shall remain in currency till next day.
Great.
Let's see, I'm preparing for respondent number 1 and 4.
Whatever 1 and 4, 1 and 4.
Item 34.
Yes. You find the counter.
This matter has come up today for the first time after after completion of service, Your Lordship. Just one thing I wanted to point out to Your Lordship before filing the counter. The rules which are under challenge, the rules of 2020, they have already been repealed in January, Your Lordship.
This January.
Yes, Your Lordship.
So,
So these are the new rules. So perhaps
so is there any changes in,
the effect remains the same.
fact
The
remains the
effect
same?
remains, Your Lordship.
Amend the petition in accordance with the similar provisions are there. Challenge the same by making this incorporating the prayer clause.
AICT, Your Lordship. Respond numbers
By
1 and
the- by this petition, the petitioner has challenged the validity of the
validity of the AICT grant for approval for technical institutions regulations 2020.
AICT for grant of
AICT grant of approvals of technical institutions regulations 2020.
please give it in writing. 2020, full stop. Then council appearing for the respondents has submitted that the above referred regulations have already been amended,
Superseded.
has already been repealed, and a new regulations in the name of
AICT grant for approval for technical institutions guidelines 24-27. I'll give that.
27 has come into force. Full stop. And then council appearing for the petitioner. You do one thing, withdraw this and file a fresh challenging the same. Because otherwise we have to amend the whole petition.
Yes, sir.
And it amounts to filing of a new petition.
It is 80%. Over procedure. If not proceeded to it, say.
2020.
If your lordship wants that I should find a new one. Incorporating.
You file a new one, challenging the if the provisions are of, still you feel that these provisions are also.
Provisions are on same as he has also said.
File a fresh petition, because now you have to change the whole body of the petition. And it amounts to filing a fresh petition.
Economics are to better.
Also, the petitioner has submitted that since the regulations of 2020, earlier regulations were 2020.
2020.
2020 has been repealed and new regulations have been affected. He wants to control the petition with liberty to file a fresh petition. File a fresh petition challenging the regulations of 2024-27. Dismiss with liberty as parade.
To me, to say to.
Item 25.
My lordship, I appear online, my lord, for item number 35, my lord.
Yes.
My lord, issue here is rising under GST, my lord, where the main issue is the input tax credit denial under section 16, subsection 4, my lord. The earlier, after admitting the petition, my lord, it was directed the respondent to file their reply, my lord.
No,
So far, it has come.
The petition is still not admitted, sir.
My lord, notice was issued, my lord.
Notice was
Notice
issued.
was issued. Yes, notice
Yes,
was issued.
sir.
Lordship, in this case, I am appearing for respondent number 3.
Yeah.
Order was passed by the state GST. However, Lordship, there are about 70 lead petition has been pending before single judge. We have filed a common affidavit in that case. Common affidavit in all the cases, Lordship. Here, their challenge is to the notice issued by the central government under section 168 capital A. That has been put under challenge. And in the meantime, Allahabad High Court and Kerala High Court decided in favor of the department. Lordship.
No, whatever it may be.
We have
You mean
already-
to say that the matter would go to the single bench?
Lordship.
Yes, Mr.
Milords, here there are two challenges, Milord. One is challenge to section 16 subsection 4, Milord.
No.
Another challenge is to notification number 9 of 2023 issued by the
You have challenged
government,
the
Milord.
validity of this act
16.4, Milord. Yes, Milord. Yes, Milord. So, as far as whatever the single judge bench matters, Milord, that is related to the challenge to notification, Milord, that is relating to the extension of time limit to pass the order, Milord. That is one of the challenge in my
challenge
petition.
to section 16.4.
16.4 is pending. with the
Yes.
Supreme Court.
Whatever it may be, you file a reply to
No,
that.
we have filed our reply in that case. Your Lordship, common
Here in this case.
Lordship, I am relying on the, I'll supply copy to my learned friend, I'll file that copy.
Milord, that issue is different, Milord. That is not related to section 16 subsection 4, Milord. That is only related to the time extension for the passing of orders, Milord, not for the input tax credit denial under section 16 subsection 4.
So if they don't want to file any reply to your petition, what we can do?
Milord, there is a interim prayer, Milord, at least till the date of next hearing or till they file reply, their interim protection has to be given, Milord. That is my prayer, Milord.
What interim protection you are seeking, since the validity
Because-
of the provision itself is under challenge, and that matter is pending before the Honorable Supreme Court.
My submission is that, Milord, this order was passed without even granting the opportunity of being heard to, Milord. There was a
That is a question of fact. That is a question.
no,
of-
Milord.
So far as regarding the validity of the section 16.4 is concerned, if that question is pending before the Honorable Supreme Court, what we can do, sir?
No, yes, Milord. Even Supreme Court also granted stay against the orders, Milord. That is my submission, Milord.
You file your reply, whatever it is.
Milord, at least till the date of next hearing, there may be stay, Milord. Otherwise, they may recover it, Milord.
Yes, Mr.
Lordship, I am appealing for the state GST. Copy has not been served upon us.
Copy has not been served upon you. Why?
I just came to know from my learned senior friend.
But your presence is there on this 6/5/2024. Mr. K. Fungal, Learned Advocate Council, Mr. N. Das, Learned Government Advocate Assam, and SCKL Central Government Council, Learned and B. Gogoi. Learned Council entered appearance on 1, 2, 3, 4 respectively.
Lordship, but today our name has not been replied. If he has got it, then Lordship, he is another colleague of mine. Lordship.
The copy of the writ petition might have been supplied to him.
Yes, Lordship, then it may have been, but our name has not been reflected. That's why we need the item, Lordship.
When you are going to file reply?
Lordship, let it come after vacation. In the meantime, we will file it, Lordship, any day.
Okay, this matter on 24th of July 2024, while reflecting the name of what's your name?
State GST, Standing Council State GST.
Reflecting name of so and so, standing council for the GST, state GST. Full stop. He may file a reply to the writ petition, counter to the writ petition by the next date of hearing. Yes.
Milord, my submission is, Milord, because now that it's been more than 3-4 months, they may proceed for recovery, Milord. At least till the date of their file reply, Milord, interim protection may be given.
We have already given this date let them file their reply, then we'll consider. Yes.
Item 36.
Milord, item number, Milord,
Yes, next.
please.
Lordship. My lord, appellant before your lordship, my lord, is aggrieved. My lord, by order dated, my lord, 29/11/2023, first in WBC number 443 of 2021, my lord. Whereby, my lord, the petitioner's claim, my lord, for completion appointment, my lord, was rejected, my lord. Here, my lord, what happened, my lord, in this case, my lord? The appellant's father, my lord, was an junior engineer, my lord, in the executive engineer, PWD Rural Road Division, Gwalpara, my lord, who died in harness on
Sir, in the year 2015,
15, my
the
lord.
requisite qualification for appointment on the post of section assistant was not higher secondary science.
My lord.
We have granted you time on 1/4
Yes, yes, my lord.
2024.
But although, my lord, I have submitted an RT application seeking the information regarding whether the qualification was in the 2015, my lord, that information not received, my lord. However, my lord, I have collected one advertisement, my lord, issued in the year 2010, my lord.
Yeah.
There, my lord, the educational qualification for sectional assistant was
So 2015,
matriculation, my lord.
what was the educational qualification for appointment on the post of this
My lord.
assistant, education assistant?
My lord. Here, my lord, kindly, my lord, one thing, my lord, kindly come to my lord, page, my lord, 46, my lord. Whereby, my lord, the DLC has recommended my name, my lord.
46.
46, my lord.
Yes.
May I read, my lord? The committee verified the economic condition of the family.
Sir, what was
Yes,
the reason
no,
for
my lord, I am
rejection?
coming, my lord.
What
Why?
was the reason for rejection?
My lord, they have now, my lord, they have rejected, my lord, in the 2019, citing that I am not qualified for sectional assistant, my lord. My case was, my lord, my case was recommended by the DLC for post
So
of junior assistant.
DLC found that you are having
Yes,
the
yes.
requisite
Yes, my lord,
qualification.
junior assistant, my lord.
So show us that
That
this
is
was
why, my
the
lord,
requisite qualification in the year 2015. We'll grant you the relief.
My lord, that is why I am coming, my lord. For PS 46, my lord, that DLC has recommended my name for, my lord, may I read, my lord, the particular system paragraph, my lord.
Read.
The committee verified the economic condition of the family and family status, education qualification as etc. of Sri Biplab Mehti, the present appellant, my lord. So I am so ex junior engineer, office of the executive engineer, PWD Rural Road Division, Gwalpara, one who expired on 13/1/2015 while in service and who submitted application on 5/2/2015 for appointment on compulsory ground. The educational qualification of Sri Biplab Mehti is BA passed and his date of birth is 1/1/1961, my lord.
Where you are reading?
16, considering the economic condition.
Where you are reading?
Page 46, my lord.
Page
46, my lord.
Yeah, clause 2. Para 2.
Clause 1, my lord. Yes, my lord. Para
Committee
5.
verified the economic, family and educational age, etc. of Mokibir Rahman. This is what?
46, my lord. Page 46, first paragraph 1, my lord. Top paragraph, my lord.
Biplab Mehti.
Yes, ma'am.
The committee verified the economic condition of the educational qualification, Biplab Mehti, so and so, that is Gopalpura expired on Ita, who has submitted an application for appointment completion of educational qualification with a BA passed
My lord.
and his date of birth. Considering the economic condition, educational qualification, so and so, recommended for appointment on the post of assistant, junior assistant.
Junior assistant. Against a single vacancy.
Vacancy, Gopalpura in the single applicant for the post. Yes, then what happened?
My lord, thereafter, my lord, that was forwarded to the SLC, my lord.
Yes.
The SLC has rejected, citing that there is no vacancy.
Fine.
Thereafter, my lord, appellant had approached before this court, my lord.
Fine.
This honorable court had rejected, responded that you should consider it to other department also.
Fine.
Now, my lord, my lord, complaints of that order, my lord, they have what happened, my lord, in the in the year 2019, my lord. The SLC has recommended the case of the petitioner, my lord, against the post of section assistant.
Fine.
Section assistant, citing that you don't possess the qualification of section assistant of ACS science, my lord, so you are rejected, my lord. Now, my lord, now kindly come to page, my lord, 68, my lord, the impugned judgment, my lord.
68.
68, my lord. 68, my lord, paragraph 8, my lord. page 68, my lord, paragraph 8, my lord, may I read, my lord? Rule 8 of the all Assam section assistant and subordinate engineers PW road wings service rules 2018, my lord. 18 states that the academic qualification of candidate for direct recruitment for the post of section assistant shall be SSLC passed from any recognized board in science stream. As such, the relevant rules require the petitioner to have the higher secondary science qualification to be eligible for appointment to the post of section assistant. Though the counsel for the petitioner had taken a stand that the other person who were having BA degree have also been recommended for appointment on compulsory ground to the post of section assistant earlier. The said argument is ambiguous inasmuch as there is nothing to show that those persons having BA degree did not have the education qualification of higher secondary science. In any event, if the state government has earlier recommended the person who did not have the education qualification of higher secondary science for compulsory appointment to the post of section assistant, this court is of the view that illegally committed by the state respondents earlier, if any, in violation of the relevant recruitment rules cannot be allowed to be perpetuated by this court. Now, my lord, here, my lord, the rule, my lord, which was framed, my lord, that was pertaining to the 2018, my lord.
So
And my case was, my lord, pertaining to the 2015, my lord.
when the appointment is supposed to be offered to you,
My lord, 15, my lord.
15, whatever it may be, sir, now the qualification is secondary science, then certainly at the time when the appointment is given.
My lord, yes, my lord.
qualification is to be
Now, my lord,
taken.
kindly come to, my lord, my additional affidavit, my lord.
Yes,
Additional affidavit, my lord, I have annexed, my lord. One advertisement, my lord. Page 75, my lord.
75.
My lord, this type of, my lord.
Yes.
Here, my lord. Page 70, kindly turn to page 76, my lord. The educational qualification, my lord. This advertisement, my lord, was issued by the, my lord. Issued by the, my lord, Chief Engineer, Irrigation Department, Guwahati, my lord.
The advertisement is dated
Date कितनी है इसकी?
Page 79, page 79, 12/8/2010.
Yes, my lord. 12/8/2010.
2010. You just.
My lord, my lord, in the year 2019, my lord, another advertisement was there, my lord. It was in 19. My lord, page 83, my lord. And I have another type copy, my lord. Page 80, my lord. Here, your lost will find, my lord, the it section is in page 80, my lord.
Page?
Page 80, my lord.
Yeah.
Here, my lord. Is section assistant in last column, my lord. Section assistant 397 number of post. Educational essential qualification kindly see, my lord. SSLC or equivalent 10+2 examination passed from any recognized board council as per draft. Draft service will be submitted to the government, my lord. Here also, my lord, no science is required, my lord. And in the year 2010, my lord, that advertisement, my lord, there was only my lord ACS passed. Moreover, my lord, another aspect of the matter, my lord. Another, my lord.
This is of the year 2012 or 19.
19, my lord. My lord, 82, my lord, it is this application proceed. The candidate had to be applied online. In the online link would be available in the development so and so. Our 20th December 2019, my lord. That was the last date, my lord. Now, my lord, another aspect of the matter, my lord. Another similarly situated person, my lord, namely, my lord, namely Devakolita, my lord. My lord, whose case was also
Which are those rules? Rules, which are those rules?
my lord, that rules, my lord, 2018 rules, my lord.
Prior to 2018 rules, which are the rules under which this appointment are to be made? Section assistant.
কিছু মিনিস্ট্রি আছে মিনিস্ট্রি
Which are the rules?
एक 2018 जब लिखा था ना इतना रूल्स था it is called All Assam Section Assistant and Subordinate Engineers Road and Wings Service Rules 2018.
Prior to that,
it was amended in 2018, Lord.
amended or repealed?
They said it is
Amended or a new enactment? Sir, what was the requisite qualification for appointment on the post of section assistant in the year 2015?
15, Malad, the science is not required. HS science is not required. Malad, it was brought in 2018 in 18 rule, Malad. Malad, the reason for it was told to me, informed to me, Malad, that the section assistant has a channel to promotion to the post of junior engineer. Ultimately, that is why science is required. So science they have brought.
Prior it was
Malad, it was
section assistant was not the feeder post for the post of junior engineer.
Well, some percentage of junior engineer is to be filled up from on by a promotion from that, but it has created an anomalous situation because the person who is promoted to the post of junior engineer, they don't have science, and that is why some problem they are facing. That is why it has.
You heard the learned concept of the parties. We are of the view that matter requires consideration, hence admit. No need to issue notices, parties are already represented. This for hearing in due course. Yes.
My lord, yeah, after vacation, my lord. After due course, my lord.
Yeah, due course. Since it is admitted, it has
My
to
lord.
be in due course. Yes.
Supplementary list, item 47 for orders.
This.
What's about this?
The last occasion, lordships wanted the names.
Yeah.
But I have received a communication. For the identity of the petition, the persons, they said that 8 to 10 women, they came to site on 22/5, but they said that identity of the members are not known to the officers.
Then you are seeking.
I am
excuse and nothing
surprised.
else.
I am surprised.
No, this is absolutely no.
This is wrong, my lord.
No, it is not wrong because I'm
Yes.
submitting, my lord, the local residents are also before your lordship, my lord. They are represented by my learned friend, my lord. There is a problem. Some persons are coming from the other side and they are doing the problem, my lord. Lordship can verify.
No.
Lordship can very well verify.
Sir, you are hiding something else and in fact, you don't want to do that.
My lord, what?
Call the executive officer tomorrow.
My lord,
Call that executive officer tomorrow here in the court.
Lordship, kindly.
Call him.
Lordship, kindly give me 1 minute time, my lord.
Call him. That's
My lord,
all.
I'll definitely call, my lord. Lordship,
We'll
kindly.
take him to task.
My lord, Lordship, may.
We'll take him to task with issue an order of suspension here only.
But
Nothing else. No, he's taking very lightly to the court.
Kindly give me 1 minute time, my lord. What the
Yes,
difficulty?
only 24 hours time, not only 24 hours, 10:30 he should remain present in
Well,
the.
definitely he will come, my lord.
Yes.
But kindly have him.
Please, sir, please,
My lord,
please, now it's more than enough.
My lord,
You granted you enough time.
Lordship, just I want to.
Until and unless this person is put to task, nothing would happen. Nothing is going to happen.
But it just would like to.
Now, you have done your best. That's all.
But the position of the road, kindly for a.
On 27/5/2024. This court, taking into consideration the submission made on behalf of Mr. D. Nath Lanet, Senior Advocate, a Government Advocate Assam, that some persons, some local residents are creating trouble and are not allowing the construction of road, construction of the alternative road leading to the judicial campus.
My lord, it's the High Court premises, my lord, Judge's Bungalow, there.
The
Malibagan area, my lord.
leading to judicial
No,
campus.
no, it's an alternative road for the people of that locality by the side of the boundary wall of the, my lord, High Court campus, my lord. They are now, my lord,
That
traveling.
alternative road for the purpose of for using of the local residents of the area. Full stop. The said alternative road is adjacent to the judicial campus.
Yes.
Having residences of the High Court judges. Full stop.
That some local residents are creating trouble and are not allowing the construction of the alternative road.
Alternative road, it stopped, comma, directed Mr. Nath to file an affidavit of the concerned official with the detail of persons who have created the trouble in construction of the alternative road. It was also ordered to be clarified that whether the land related conflict at lower Malibagan point has been resolved or not. Full stop. On 18/6/2024, Mr. Nath sought time to disclose the names of the persons who are creating trouble in construction of the alternative road. Today, Mr. Nath has submitted that the executive engineer has informed him that the persons who are obstructing the construction of the alternative road are not known to him, and therefore it is not possible to identify the members of the group. Full stop. It appears that the executive engineer is taking lame excuses for not completing the construction of the, for not completing the construction of the alternative road. Despite the time line fixed by this court, despite the deadline fixed by this court as May 2024. Full stop. In such circumstances, we are forced to summon the executive engineer before this court tomorrow. Mr. Nath is directed to instruct the executive engineer PWD New Guwahati Territorial Road Division Guwahati to remain present personally before this court at 10:30.
Kindly allow me.
We'll hear you tomorrow.
A minute time.
We'll hear you tomorrow.
Uh,
We'll hear you tomorrow.
Can you see the next page?
Ask the executive engineer to remain.
He will be here. He will be here.
That's all.
He'll be here.
It's all.
Item 48.
D below.
May I please, your lordship? My lord, as per this honorable court's order, the record of the another case also is before lordship's lordship. I would like to submit lordship. In this case, he is declared as a foreigner, both the petitioners. Two references taken together, they were declared as foreigner. Prior to that, there was another reference wherein they were declared as a stream foreigner and subsequently they have registered. So as per law, they have registered as per that order. And that they have not placed this order while the second reference was made and before the learned tribunal. So my humble prayer before lordships will be, as per the Honorable Apex Court order, this case may be remanded back before the tribunal so that they can submit the order and then registration. And with that regard, I would like to. Yes, lordship. May I?
In fact, we are not having roster of this. Hearing this.
Yes, lordship. Since the matter was fixed, this is the reason this is placed before lordship.
Before the another bench which is assigned to hear these matters.
Because notification is there, lordship, I cannot appear before the assigned bench, lordship. That notification is flagged, I think Y or X is there as per office note, lordship. Y. This is the reason, since the matter was fixed, this is the reason matter is before.
They may fix the matter for hearing, lordship.
There was 19 matter based on Supreme Court judgment, lordship.
Since we don't have the roster, is this matter on? Fix this matter in the summer vacation.
Yes, lordship.
The summer vacation. Date. Yes. That's all.